Full house today. Well, we have 7 hours of argument time that has been requested, so I am going to give my usual spiel. We are familiar with your cases, your briefs, and the record, usually more than you wish we were. So I need you to ask for the time that you need, not the time that you want, so that I don't have to cut the time down for you. Understand the clock and the time I give you is your clock, not the court's. So if my colleagues have additional questions because your argument is so brilliant, I will allow the questions to proceed. Okay? That being said, let's begin with the call of the calendar. People versus Carlos Medina. I'm sorry? Okay, you weren't listening. Go ahead. 4 and 1 and 4. Gu versus Henry. 4 and 1 and 4. P. Sheena versus James. B is submitted. Sapata versus Edwards. Okay. 4 and 2 and 4. Metropolitan Partners versus Nerie. This one requires a little more argument time, so I don't want my pre-admonition to scare you. Now give me your answer of how much time you need. Okay, I'm not gonna be that generous, but how about you? All right, 7 and 2 and 8, and I suspect that with my colleagues' questions, we'll probably get into the territory you're in. All right. Salas versus New York Presbyterian Hospital. Okay. 5 and 1 and 5. People versus Khalik Robinson. Submitted. Certain underwriters at Lloyd's versus Southwest Marine and General. Okay. 6 and 2 and 5. Nerie DLO Securities litigation. Good morning.
Good afternoon.
Okay. That's exactly what I had in mind for you, gentlemen. 7 and 2 and 8. Warerki versus Bronx Community Board. Okay. All right, 5 and 1 and 5. S. Antonio versus Rita S. is a submit. Riley versus Memorial Sloan Kettering.
Estate of Kainer.
Oh, I'm sorry. Give me 1 second. I skipped one. Estate of Margaret Kainer versus Christie's Inc. Okay. 5 and 2 and 6. Now Riley versus Memorial Sloan Kettering. Who's the first appellant? How much time? You're plaintiff. You're plaintiff. So, you guys.
Your Honor, if I may, the parties are appellants in some capacities and respondents.
All right, we're arguing it all at one time, so give me what time you need for argument, whatever it is you want to argue, and what time you need for reply. We're not going back and forth 5 times. Go ahead. Okay, understand that the defendants who are appellants, you have to share 15 minutes. So let me cut to the chase, and what I see is 4 and 1 for JGN, 4 and 1 for MSK. ATCO gets 4 and 1, that gives us 15 minutes. And of course, if we go over the clock, you benefit from that, okay? And plaintiff, you get 6 and 2. All right, 4 and 1, 4 and 1, and 6 and 2. Thank you. Travelers Indemnity versus Southwest Marine and General. Okay. All right, I'm gonna do 5 and 1 and 5. Okay? Do you have a cross appeal, plaintiff? And you are the first movement, right? Okay, so 5 and 1 and 5 and 1. Okay? Great. Reyes versus Height Construction.
Good afternoon. The appellate, 3 and 2, please.
Okay. 3 and 2 and 4, thank you. Lee versus Luck. Okay. 6 and 1 and 7. People versus Christian Rojas. That's a submit. Waddell versus City of New York is a submit. First case on the calendar, People versus Carlos Medina. Oh, and for the record, my colleague, Margaret Chan, as you see on the screen, is participating. She's in the courthouse, is not feeling altogether 100% well, so thought it best for her to sit from her chambers. But she will be participating, and please pay attention should the voice from the screen talk to you, okay? All right, you may proceed.
For Mr. Medina, Your Honors, both the SORA guidelines and the corrections law recognize that the risk assessment instrument, the RAI, was not designed to capture the nuances of every case. And so they both provide courts with the option of a downward departure to avoid an overassessment of a person's
Where is the
risk level.
overassessment?
In this case,
On a 51-year-old who pretends to be a police officer and lures a 12-year-old to her rape. Tell me where the misassessment is.
there are a number of factors in which the RAI, Your Honor, either does not at all or imperfectly captures the nuances of this case. And there is not a dispute here that this is a serious case. However, this also represents a one-time misconduct on the part of Mr. Medina, who otherwise never had any kind of
One-time
contact.
conviction.
That's correct, Judge.
Right.
And there, as stated, there are a number of different factors, as stated in my brief, there are a number of different factors that the RAI doesn't either account for fully or accounts for imperfectly. And one of those factors I'll begin with is his correctional record, his disciplinary history, where during the course of his incarceration, he did not have a single disciplinary violation. And in addition, he engaged in rehabilitation. I'll get to the details of that in just a moment. And on the basis of this record, he was granted a rare privilege by correctional staff, which is preferential housing, which you don't see very often and is based on an individual's exceptional conduct while they're incarcerated. Similarly, his performance in the sex offender treatment program, as you can see, that's Exhibit A of the hearing record, for the defense. And in his monthly evaluations, Mr. Medina consistently scores in the highest possible score category. There's really not one month where he is just simply a successful, if average, participant in the program. So I would argue this is precisely the sort of
Counsel, didn't the court take all this into account?
well, the
And
court's
particularly in regard to the defendant's lack of a disciplinary record and participation in vocal training, no points under Factor 13.
Right. And so when you are talking about Factor 13, if you look at the SORA guidelines, it says if a person has a serious disciplinary record, they should be scored points. And as I stated in my reply brief, that leaves a whole range of action.
You're arguing the judge gave no points. So I don't understand what the problem is. You are suggesting that on the basis of that, in addition to getting 0 points under that category, somehow it should deplete his numbers in another category. That's what you're arguing.
What I'm
And there's
arguing,
no case law that supports that proposition. Is there?
well,
Has a
actually,
court ever done that?
So-
Switch the points from one category into another in order to downgrade.
what the court has done, and this court has done, for example, in People v. Williams, is note that, for example, in Factor 13, which covers conduct while confined, the RAI does not adequately capture the exceptional degree to which the defendant conducted himself, and that's
What are you suggesting, though? If he gets 0 for that, which means he got no bad points for bad conduct, the best he could get is 0. What are you suggesting? That there be a new category created where they get minus points?
So what I'm arguing, as I did in my reply brief, is this. By design, the RAI sets to account for serious misbehavior, but it cannot distinguish between an acceptable disciplinary record with some misbehavior and an exemplary one with no
You're not
misbehavior.
answering my question. What are we supposed, what is it that you are suggesting? Because there's nothing wrong with the zero calculation, correct?
That's right.
You're not saying he should have added points, right?
No, not at all.
The judge was correct in saying zero for that category.
Right.
So what precisely did the judge do wrong? Where, in what category should the judge have reduced in order to get to the preferred outcome you want?
So two things. First, the judge doesn't explain the basis for denying downward departure. You'll see in the decision, it just says.
Your
"I'm denying
focus,
it."
counsel, now you're going to a general argument. You were focused on this particular issue. So I've asked you a direct question and you're not answering. So if you want me to consider your argument, you actually have to answer my questions.
Right, so like I said, the risk factor gives you 0 points if you have excellent disciplinary history, or if you have sort of an average one, meaning, as the guidelines point out, it's not appreciating the nuances of a case. It can't distinguish between
But there's no, again, there's no better outcome than zero.
Well, but-
So I don't understand where we are supposed to subtract from.
The downward departure is your mechanism for subtracting from the total score.
Right, and it requires us to subtract from a particular category, right? We can't just say, you know, I don't like that 120 number. I'm gonna chop it down to 100 and not explain where, right? So tell me where.
I just want to make clear, no, that's not my understanding of how the downward departure works, because you can have the presumptive risk score, which is a number, right, that the RAI calculates. But when you downwardly depart, that doesn't require you to provide a final score calculation. And if I'm misunderstanding the court, please tell me. So you have the presumptive
Your
risk
point
score.
is, I don't want you, I'm not asking you to disturb the score that the SOAR court assigned. What I'm asking you to do is apply Galati.
That's right.
And in light of Galati, afford me a departure.
That's right. So the presumptive risk score is what it is. The court doesn't have to reach a separate risk score to downwardly depart. It can do that because the case, as Your Honor stated, satisfies the three-part Galati test. There are mitigating factors, they were proven by a preponderance, and given the overall circumstances, a departure is warranted. And I bring up Williams, and I would also like to contrast this case to the cases cited by the people, because this case is more like Williams and can be distinguished from the cases that the people cite, such as People v. James D., People v. Godsend, People v. Frederick, because in all of those cases, even though there are alternate bases for the court's decision that a downward departure was a provident exercise of discretion, the court also notes, listen, there are other aggravating factors here.
Well, I guess back to Judge Manzanet, Daniel's underlying question, which was, what's the extraordinary mitigating circumstance or circumstances
I
that
don't-
would warrant disturbing? Because normally it's a discretionary determination whether or not to grant an upward or downward departure. So you're up against that barrier as well. So what is the extraordinary mitigating circumstance?
Right, and that is a demanding standard. Here, it isn't just one factor, it's several factors, and they all deal with his conduct after his conviction. His disciplinary record, which again prompted an unusual commendation from correctional staff, his performance on the SOCDP, which was never less than the highest possible evaluation scores, his support from his family. There are 8
Counsel, as to support from his family, didn't he have this family when the incident occurred?
Yes,
And didn't the court take this into account when it scored 0 points under factor 15?
the court takes into account the fact that he does have, he's being supervised while he's released. There would be no difference to the 0 points if he had 0 letters of support or if he had 8 letters of support like Mr. Medina does. So again, the RAI does not capture the nuances of the case.
All right, you'll have time on rebuttal.
Thank you.
Maria Wager for respondent, may it please the court. It was a provident exercise of the SORA courts to deny defendant's application for a downward departure. His proffered mitigation, which is the no disciplinary record, support from family, friends, and engaging in treatment and training while incarcerated, was accounted for in the risk assessment instrument. As this court has pointed out, he was not scored any points, risk factor 12 through risk factor 15, which included acceptance of responsibility, conduct while confined, supervision, and living employment situation. But even if his proffered mitigation was not adequately accounted for, there is nothing exceptional here. He's doing well. I don't want to take that away from him, but he was doing what he was supposed to be doing, and in a controlled environment, which is,
And counsel, when this crime took place, didn't he have this family?
he not only had this family.
Didn't
Your
he
Honor,
drop the victim off to his home after the crime and ask them to take her wherever she, am I wrong?
Correct. So he already had this family and the fiance. When this happened, he took the victim to a motel. After the sex acts, he took her to his home and had someone, he called someone, I don't know who that is, I could not, it's not part of the record, to bring her back to the street where he found her. And she was suicidal the next day. and
When she called the police, she was suicidal.
Yes. So he had that same family then. And also, I just want to mention with the drug treatment, he admittedly was using since he was 16, up until the time he committed these crimes in his 50s, was admittedly under the influence of substances that night, and used substances with the 12-year-old girl.
How old was he at the time?
I believe 51.
And how much time has he been out for us to assess how well he's doing post-release?
Your Honor, I'm sorry, I don't have that information, but I
Okay.
could get it to the court. I know that the SOAR determination was made shortly before his release.
And weren't the notes about his participation, didn't it indicate that they were satisfactory as opposed to exceptional or transformative?
Right, I don't see anything exceptional or transformative in those reports. He was doing well, and as I said, that's what he should be doing.
We certainly want to encourage that.
Yes, but I don't think it rises to the level of departing from his presumptive risk level. And there's another reason I just want to finish up on, is it's all outweighed by the seriousness of the offense here. So not only is it a 12-year-old victim, it's not just the sex acts that were perpetrated, but it's the way he achieved access to the minor. He asked her, she came from Connecticut to see her boyfriend in the Bronx, and he asked her if she wanted to come with him to smoke and drink, and she turned him down. He left and came back in his car, showed her a police badge, said, "I'm a police officer, I can take you to my girlfriend who will help you." There's something very devious and manipulative and very troubling as far as risk to society goes with that. They're clearly, and then as you pointed out, he just had her dropped off at the street where he found her by
He
someone.
didn't drop her off.
No,
had
he didn't even drop her off.
Someone from this supportive family or circle of friends, we don't know who.
I don't know who.
Assist him.
Right, so there's no overassessment here, and I would ask that you affirm the SORA court's denial of this downward departure. If there's no further questions, thank you.
Thank you. Counsel, you have a minute on rebuttal?
Thank you, Your Honor. I just want to clarify, the SOAR hearing happened in 2024, so he's been out since then.
June, right?
That's correct. The insinuation that there was possibly someone from his family or friend network is raised for the first time in the people's reply and now on arguments. There is no such indication in the case record, and I would just like to know that the
Did
case,
he drop her? Does the record indicate he
it
dropped her
indicates
off?
that
Does the record indicate he dropped her off?
No, it
So
doesn't.
someone else dropped her off?
it could be like a cab driver, for instance. And I just want to note that the case record included 3 surveillance videos, one of which included his home. If at any point in this case there was some indication that a family or friend was involved, there was surveillance footage of his home. But I also want to note, in terms of I am acknowledging the seriousness of this case, and we don't intend to minimize that, but I am emphasizing that the RAI really primarily looks at the facts as they exist at the time of his conviction. And that's the holding of People v. Williams in this, which this court decided, which is that the RAI cannot account for circumstances as of the time of release. Thank you.
Thank you so much. Gu versus Henry. You have 4 minutes, ma'am.
Thank you, Your Honor. Good afternoon, Your Honors. I'm Appellant Feifei Gu. May I please the court? Since Alvin Bragg, district attorney, assumed the office, day one, he implemented his soft on crime municipal policy. And thanks to this policy, prosecutors live in paradise because felonies are downgraded to misdemeanors and misdemeanors don't need to be prosecuted. And on the other hand, crime victims live in hell like me. So my story is one example, and here is my case. I was assaulted by a Uber Eats delivery person named Debbie Chiata. When my case finally reached to the DA's office, ADA Javon Henry was assigned. I forwarded him all the evidence I have. However, he did not submit anything to the court. And also, when I asked if I can go to the court hearing, he said no. He did not allow me to go to the court hearing. He did not inform me any case status. And finally, when the case was finally disposed, he did not inform me. I found it myself. So that is what Javon Henry has done for this case. Nothing. I was denied the crime victims' rights. I was initially blocked every information of the case status. So even though Alvin Bragg was reelected, it does not mean that his soft on crime policy is correct. And there needs to be someone to stand up and then to tell him, you need to shoulder liability. Here's my case. So my case against the Javon Henry and the DA's office was finally dismissed. It was understandable to some point because on the one hand, it's DVA's office. It's a powerful entity. They are a frequent player in the court. On the other hand, it's me, just a normal human being that can be sacrificed. But I want to stand here today. I want to tell that my story represents millions of them who suffer the same. The lower court ordered dismissal for 2 main points. First of all, it's the summons and complaint was even not served, so the motion to dismiss is premature. And second, there's no service of the motion papers. The respondents claimed to serve it via certified mail, but certified mail was never delivered to me. Well, Victor O's the person sitting next to me, he claimed that I'm frivolous, I harassed him, and also he filed a motion to the court regarding this. However, he's a person who tampered with evidence and falsified proof of service, and even made false accusations that I'm harassing him. When just that day, I and another server went to the DA's office to serve the summons and complaints, amended one. When we went there, the security guard told us, well, he's not there. And then we replied he left. And then since then, he began bargaining in court day and day that I was harassing him. So how did I harass him? Nothing. I just went there, applied he left. And he was like, I'm sorry, sir, but the DA's office is not your residential place. I did not come there to disturb you. It's just your working place. And you did not live there. You do not own that building. I'm so sorry about that, but I did not harass you. So that is just the lower court denied the motion to dismiss, denied the sanctions. And actually, I want to say this is also a case prepared for the Court of Appeals. Just imagine, so one day you or your loved ones was on the street and you were punched by a random person. And then when when your case finally reached to the DA's office, you were told by the ADA, I'm sorry, we cannot prosecute this case because it's not a big deal. Or in the alternative, they could say to you, yes, we will prosecute your case, but in fact, I'm sorry, we're going to do nothing because we will let the case die itself. So this is my case. This is a case prepared for the Court of Appeals because, first of all, regarding the prosecutorial immunity, it's not applied here because I'm not the defendant in the criminal case. I'm the complainant of the criminal case, and I'm suing for the violation of crime victims' rights. Does it apply?
I'm going to give you time on rebuttal. Your time is up now.
Sure, thank you.
Okay.
Good afternoon. May it please the court, Your Honor. Victor Oles for respondents, Javon Henry, Franchini, and the Witness Services Unit of the District Attorney's Office. Your Honor, the crux of Ms. Gu's complaint is that she is displeased with the fact that the district attorney made a determination not to proceed with an investigation where she was the complainant, the underlying
She
complainant.
was beaten up pretty bad, wasn't she?
I don't know if she was. That's
Well,
her
she
allegation.
claims she was. And so, look, having been a defense lawyer, I understand that the DA's office has prosecutorial discretion, right? But the fact that this case is here tells me perhaps that the office has failed to properly deal with this victim, speak with her with respect and dignity so that we don't end up here, because she doesn't understand the level and the extent of the prosecutor's discretion. I understand it, but did anyone ever sit down with her prior to ACDing her case?
Your Honor,
Did anyone ever sit with her and explain to her the process of the system? I mean, it seems to me like that is the least that we can expect from our prosecutorial arm, because victims come to the court with zero experience of the process. And if they don't understand the process, this is what happens.
Your Honor,
So did anyone explain to her the proper process and deal with this victim with courtesy and respect?
yes, Your Honor.
Okay, tell me about that.
Well, I was not involved in the underlying process, Your Honor. My
But
understanding.
I'm assuming you know, because if you say yes,
Well,
that means you've spoken to the people who have treated her with courtesy and respect and explained the process so that we shouldn't be here.
Your Honor, I wasn't privy to any conversations, just to be clear, I was not privy to any conversations that Ms. Gu had with our office. I got this case years after those events occurred. When I said yes, what I meant was that we have a designated unit that whose resources are committed to discussing just the concerns that Your Honor is raising. It's the Witness Assistance Services Unit. And I understand how that unit operates generally. And its function is to discuss.
But you realize that how you operate generally doesn't meet the test for dismissal.
I do, Your Honor, but
I need to know, how was she dealt with on this case, right? Did someone talk to her and explain to her why the prosecution felt that an ACD was appropriate, even though this Uber driver beat her?
well, Your Honor, in the first instance, I don't really know specifically why the case was dismissed because the case was sealed. And as I say in my.
But it's undisputed that she learned of the dismissal on March 5th, 2021.
I think
So
she-
no one called her to say he got an ACD and dismissed.
I actually think she learned of it before that, Your Honor. If you look at her notice of claim, she indicates that she learned of it sometime in February of 2021.
She learned it from this unit that helps victims?
I think she learned it directly from Javon Henry, who was an assistant district attorney.
Do I have an affidavit to that effect in these papers?
I don't believe there is an affidavit in terms.
Why not?
In term,
If that is the basis for your defense, why is that not in the papers?
that is not the basis for the people's defense, Your Honor. The basis for the people's defense really is twofold. One, jurisdictional, and two, the fact that the claims against these defendants are barred by prosecutorial immunity. I see my time is up. If I could
Oh, you
just.
can keep talking
Thank-
until
thank
I stop you. You can keep talking. And I want to hear what you have to say.
Thank you, Your Honor. I appreciate the court's courtesy. With respect to the jurisdictional point, Ms. Gu failed to comply with sections 50E and 50I of the General Municipal Law with respect to the filing of a notice of claim. She didn't file her notice of claim within, she didn't serve her notice of claim on the people within 90 days of the claim having arisen. Moreover,
Meaning as of the ACD determination?
Me-
Because the ACD doesn't become complete until 6 months after the ACD plea is entered. You know that,
yes,
right? It's not complete because if he messes up anywhere after the ACD plea is taken and 6 months after when the court then administratively dismisses. So that case did not become ripe until 6 months after the ACD, assuming that the criminal court actually followed through and processed the ACD. Do I have proof of that in this record?
No, Your Honor, I don't even know that it was an ACD because as I indicated earlier, the record is sealed. All we know when we get a sealed
But
record.
you would be able to know whether an ACD happened.
No, Your Honor,
No, a rap sheet would tell you whether an ACD happened. Again, I practice in the criminal side
Your
for
Honor,
a long time.
Your Honor, the entire file is sealed to me, and I made an application to the court to unseal
The file may be sealed, but this defendant's rap sheet is not. And the rap sheet would reveal whether an ACD was, in fact, done on the record and what day it was done. And a rap sheet for the defendant who beat her would tell us that. And you know that.
Well, Your Honor, I don't know that the defendant was beaten. I know that those were the allegations that were made.
Wow.
And I don't know that, Your Honor.
Okay, thank you.
May I just
Go ahead.
complete my argument? With respect to the jurisdiction,
That's a disappointing argument, I gotta tell you. I don't know that she was beaten. That's where we are now with this?
no, Your Honor,
Not, I'm sorry, we dropped the ball. Someone should have called you ahead of time if we did it. No, now we don't know whether you were beaten.
Your Honor, I'm trying to be forthright in my representation to the court, and based on the materials.
So the DA's, okay, I remember the file was sealed, so you don't know anything.
I really don't know the underlying facts, but Your Honor, what I'd like to address, if I may, in just the last 60
No,
seconds.
you have no more seconds, but go ahead.
So there are two issues with respect to jurisdictional point.
No. I have your papers. Thank you. You have 1 minute.
Thank you, Your Honor. First of all, no one informed.
When did you find out that there was going to be an ACD?
Your Honor, I found it myself. No one informed me anything. I found it myself that the case was dismissed on March 5th, 2021. Yes. And
How did you find out?
How did you find out? Is my colleague's
I
question.
found it online because I got a person that was familiar with the system, and she told me, you can go to the website, like, blah, 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 and I found myself, oh, it was finally dismissed. I didn't know anything about it. So it's comes as a surprise. And then regarding the 90-day notice, I did file it. It's on NICIF number 36. And also, I want to reiterate one thing, is that the lower court wrongfully rejected my amended summons and complaint. I did not serve as an original summons and complaint. When the Victor was filed a motion to dismiss, and then I want to amend it, so I submitted amended summons and complaint, and the court rejected. But actually, it was never served. And
I have your papers. Thank you both.
thank you, Your Honor.
Sapata versus Edwards. You may proceed.
Thank you. Thank you, Your Honor. May it please the court, Lori Parkman for the plaintiff appellant. In this case where an articulated bus sideswiped and ran over a bicyclist, the Supreme Court improperly granted summary judgment when the evidence raises numerous issues
So the
of fact.
video shows your client on the sidewalk for quite some time after the bus has proceeded forward. I saw the video. So
Right.
video speaks 1,000 words.
Well, the video.
And I have a photograph, a still photograph from that video of a double articulated bus, and your client's bike wheel is at the end of the bus by the doors of the second articulated portion. So tell me how that would correspond with your argument.
Right, but the video here is inconclusive. It's notable
So
for,
I didn't see what I saw.
you did see his tire, well, first, it doesn't show the accident. It doesn't show when he merges in. What it does show
What
is
I
that
do
still-
know, what I do know is that the bus is ahead of him on the reel. Then the next time I see the bike, he's on the side of the bus.
Right, the photograph, the still at page 65, what that does show is that plaintiff, as he testified, was next to the bus, parallel to the bus, riding his bike. Defendant's theory of the case was that plaintiff rode his bicycle into the bus. That still of the video disproves that theory of the case, which they were using to attempt to show that plaintiff was the sole proximate cause.
What in the video shows that the bus was negligent at all? The bus was proceeding straight, and a bike decides to drive along the inner side against parked cars and between a double articulated bus. Where is the negligence on the part of the bus driver?
The video is not the only evidence. The video does not disprove there's replete with testimony from both plaintiff and a completely disinterested eyewitness that the bus was going way too fast, it was way too close.
And the eyewitness's testimony was completely rebutted by the evidence of the video.
I would disagree, Your Honor, for what the video does not show. The video does not show the critical period of time in between when plaintiff was on the sidewalk and when plaintiff was riding next to the bus.
Counsel, what does record 65 show again?
That is a screenshot of the video. You can see the the bicycle tire in the window past the man there. You can see that it is going parallel. It is for some period of time before the accident. That's completely consistent with the testimony that he was riding on the road before the accident happened.
No, he actually doesn't say that in your client's own EBT testimony contradicts what you just said. His own EBT testimony contradicts what you just said.
I would refer you back to the record. The plaintiff clearly testified that he was riding on the road
and when he
parallel
was
to
shown
the
that
bus
portion
before
of
the
the
accident.
video, his response, let me find it. His response was, oh yeah, maybe that's where I was. He wasn't even sure. His response showed a lack of clarity. Yeah.
Well, what must be remembered is this is a defendant's motion for summary judgment. They have the burden of showing that there was zero negligence on the part of the bus driver that
So
contributed.
if we think that, tell me what you put forth that rebuts their showing. If we agree with that argument, I'm not saying we do. If we do, what did you put forward to rebut it?
All of the testimony of the plaintiff, a disinterested eyewitness, the testimony of the bus driver himself, he admitted that he knew the back of this bus shook back and forth. He admitted he did not see
So
the
what
plaintiff.
is he supposed to do about that? What does that, I mean, the fact that a bus shakes, an articulated bus, shakes back and forth, he can't change that, right? And he also can't change a bicyclist who decides to ride between parked cars and the side of a bus. He can't change any of those two things, but you'll have time on rebuttal.
Thank you.
You may proceed.
Good afternoon, Your Honor. May it please the court, Jeremy Pepper for the transit respondents. This court should affirm plaintiff's allegations as to the mechanics of this accident are directly refuted by the video evidence, which
Well,
shows...
the video, now to play devil's advocate, doesn't actually show the accident, right?
But if
So isn't that then a question of fact?
you read the plaintiff's testimony, and he's very clear on what he believes happened here, which is that he was riding his bike in the roadway when the bus passed him going too fast and then cut him off and knocked him off his bike. If you watch the video, it is clear that when the front of the bus passes him, he's still on the sidewalk. So what he testifies happened could not have happened. Now, they're potentially trying to reverse engineer an alternative form of liability here, but it just doesn't match up with the testimony given by the plaintiff.
Can you address Marlo Bennett's testimony?
Yeah,
with regard
so
to
I
how
would.
this happened?
I'd like to start off by just pointing out that it's my view that the testimony is incredible as a matter of law. I mean, that witness repeatedly testifies that the bus was going freakishly fast, refers to it as a bus out of hell from Starsky and Hutch.
And what the record shows is that the monitor on the bus shows that the bus didn't go above 18 miles per hour.
So, and I know that they pointed in their reply brief maybe drew questions to that. But if you look at the other cars in the video, it's clear that this bus is going with the flow of traffic. So unless all of the cars pictured were also going freakishly fast, I would posit that that testimony is pretty unreliable.
Is there any evidence in the record indicating what the speed of the bus was?
Yeah, well, the video includes a speedometer, and the speedometer shows that it was, I believe, going no faster than 17 miles an hour, which is well within the speed limit for that area. But I would also just address that similar to the plaintiff's testimony, Ms. Bennett testifies that the bike was already in the roadway when the bus passed, which is clearly refuted by the video. I would just like to point out that a driver with the right of way is entitled to assume that other drivers are going to follow the rules of the road. The bike here improperly merged into the roadway when it wasn't safe to do so, and there was nothing that the bus could have done to avoid this. If there are no other questions, I'll rest on my brief.
The record reflects that he wasn't even aware, the bus driver wasn't even aware that there was an accident.
That's correct, because he wouldn't have seen the bike if he entered after the front of the bus. This bus driver doesn't have eyes on the back of his head. The back of the bus is not independently controllable from the front of the bus. All he can do is react to the things that he sees in front of him.
And I am accurate that the bus was a double articulated.
That is correct, which, yeah,
Okay.
that is correct.
Thank you. I'm going to give you his leftover seconds for yours. Go ahead.
Thank you. A couple things. First, about the eyewitness testimony and the speed. He relies on the speedometer, which we pointed in our brief, we're unclear if that's accurate, but the more important thing is that the standard under VTL 1180 and the case law is that you can't go too fast for the prevailing conditions. While other traffic may have been moving at the same speed, the bus driver was aware that it was a large bus, and he was aware that the back of it moved back and forth.
How do we reconcile your client's deposition testimony relating to the footage from the bus with your position that a genuine issue of fact remains as to whether the driver was negligent?
Well,
'Cause he seems to walk through like second by second, several seconds in the appropriate frames. And it seemed to me at one second he's saying, yes, that's me on the curb from the vantage point of the front cameras. And then within a second or two or three, he's out of focus. Now he's being picked up by the camera in the back. And that's when he's in the street. So how do we reconcile that, his testimony with respect to the video?
Well, first, I do need to point out that their brief is inaccurate as to his testimony of those seconds. He did not, they say in their brief that he testified that he was on the sidewalk 1 second before. He actually testified the exact opposite. And that is, he testified that at 4:39 and 0 seconds, they asked, does that just depict your bicycle in the roadway? And he says, I don't see it, but I know I was on the street because it was 1 second before the accident and I was on the street. The thing I also want to point out with the forward-facing camera, we point out in our briefs, it's not exactly the view of the driver, it's a few feet ahead. And in a case like this where these matter of seconds are crucial and not shown by the video, and the bus is going a lot faster than the bike, the video doesn't show the seconds between how he got from the sidewalk to the street. It does show that he was going parallel to the bus in the second before, which disproves their theory, which would make him the sole proximate cause, that he ran in. That itself is disproved by the video. The video is...
Thank you.
Oh, thank you.
Metropolitan Partners versus Nerie. You have 7 minutes and you may proceed.
Thank you, Your Honors. Good afternoon. In August 2022, the plaintiffs, a sophisticated group of New York City-based lenders, made a loan to Schweitzer RSG LLC, a helicopter company based in Texas. And due to purported loan defaults, they sued Schweitzer in January 2025. The court's familiar with this case. On June 10th of 2025, this court unanimously affirmed the vacatur of an attachment order. And in so doing, this court found that the plaintiff's allegations against the company, the debtor, Schweitzer, were threadbare, against all the company defendants, not just Schweitzer, that they were threadbare. We've called these companies the non-signatories because they.
That was at the initial stage, pre-discovery, so don't read too much into that.
No, I
Yes.
understand, Your Honor. Of course,
All right.
of course, the standard is different on a motion to vacate and now on a motion
And
to
a lot
dismiss.
has
100%.
happened since, is my point, but go ahead.
Okay, thank you. But the plaintiffs are suing those non-signatory companies under an alter ego theory. And plaintiffs' alter ego theory just does not work. Piercing is permitted if Schweitzer, the debtor, is a sham. It's not a sham. The plaintiffs plead that it's an operating helicopter company. It makes helicopters. To this day, a receiver that they installed over a year ago is still operating the companies. And the plaintiffs bear the burden of proof to show that there's jurisdiction over every single one of these entities. But if you look at their allegations, I really implore you to read their complaint, and I'm sure you have. They are virtually all collective allegations. I mean, RSG Aviation, for example, one of the defendants, is only specifically referenced in paragraph 23 of their complaint. And it's just the party allegation. This is RSG Aviation, they're a Texas company, here's their address. Same thing for RSG Products. Our Rotorcraft and RSG Aero Design, the only specific allegation against them is one that's clearly false. It's that they admitted in a Texas case that they were alter egos. But we provided the pleading to the court from the Texas case. They didn't admit it, they denied it. That's exactly the sort of 3211A1 evidence that utterly refutes the allegation and supports a motion to dismiss. So the non-signatories do not belong in this case. They need to be thrown out.
Is the plaintiff at a disadvantage at this procedural juncture?
Not at all. They are not at a disadvantage. They have never been more advantaged, Your Honor. They control the company. They have more discovery than anybody, any plaintiff could ever have, and they have had it since before they made this complaint. They have had it since February of 2025, and in addition, since July of 2023, they had what's called the Deposit Account Control Agreement. They controlled and had full access to the debtor's bank account. Bottom line is, if there was money moved that shouldn't have been moved, they would have seen it. We would have heard it by now. We haven't. All they have are that before this loan closed, there was a transfer of money, but that was before the loan closed. After, they have two transfers that this court found when vacating the attachment were immediately returned. Standard is different, Your Honor, but money going back and forth, that's just a fact. We don't need to, the standard has no bearing on that. The plaintiffs also sued two individuals, Brian Nerie and Mr. David Horton. And the crux of their case is basically, comes down to four things. They looted the company, they falsified this inventory, they induced others to report fictitious financials, and they interfered with the plaintiff's rights under the loan documents. But Mr. Nerie, one of these defendants, made a significant investment into the company after the loan closed. That's not looting, that's the opposite of looting. He was the piggy bank. He didn't treat the company as the piggy bank. And again, the plaintiffs rely on these several transfers that this court already found were immediately reversed. There's just no looting here. So the inventory fraud is also just irreconcilable with the simple fact they did their own appraisals. What they point to is that this company was formed, Schweitzer, the debtor, was formed with the acquisition of parts from Sikorsky, the aviation company. And that there was an arbitration against Sikorsky because there were parts that were not delivered to Schweitzer. And that Schweitzer won that arbitration. That award was from 2020, May of 2020. The loan was 2 years later in 2022, and in June of 2022, they did a physical, on-site inspection of the inventory. So how could they possibly have counted parts that weren't there? They must have counted the parts that are there. And this court has said time and again that when you are a sophisticated party, as the plaintiffs are, they're professional lenders.
Even sophisticated parties can be defrauded, counsel.
Of course they can, Your Honor.
So don't give me that blanket statement. That doesn't win the day.
What does win the day is they did their own appraisals and they counted what was there. The Sikorsky allegations.
They counted all those thousands of tiny little parts? Really?
So there are 3 appraisal reports that are in this case and that are in the record, and one of them points out that it was one of the, I can't remember the exact phrase.
Yes, I remember.
Yes.
It reminded me of another report of how beautiful the medical report was. Please, okay, come on.
But Your Honor.
What we know is that there is a discrepancy between the first accounting of the inventory and what was actually there. What we also know is that some of these parties that are intertwined considered that lot of inventory like their little cookie jar. and they would go in there and pick up pieces that they needed to fix other planes. So there is enough in the record here to overcome, no?
No, there isn't, Your Honor. There are 3 separate inventory appraisals that the plaintiffs obtained from their own appraisers showing that the inventory was good. And the fact that there were parts that weren't delivered by Sikorsky 2 years ago, I don't see how that could have any bearing on the on-site inspection that was done in 2022, 2 years later. If there had been missing parts, why didn't the 3 appraisals that they commissioned say there were missing parts? None of them ever said that. And their own allegations, if you look at paragraph 80 of their complaint, Your Honor, this is what they say. Okay, they say, those appraisals show that the Schweitzer inventory in 2023 and 2024, so a year and 2 years after the closing, were inexplicably and radically lower than represented to Metropolitan in 2022, and this is the kicker, without significant change in the physical inventory or sales. There was no change. What happened was the value of the inventory dropped, not that there were missing parts, and one of the plaintiff's own appraisers explained this. This is on the record, page 724, Your Honors. They explained it that it was due to softening market conditions, rising interest rates, and political uncertainty, not due to missing inventory. So again, if there was in fact missing inventory, one of their appraisers would have mentioned it.
Thank you. You'll have time on rebuttal. You may proceed.
Good afternoon, Your Honors. Vivek Tata, Ellsberg, Baker, and Nerie on behalf of respondents.
With respect to the inventory issue, why isn't counsel's argument correct? You had your own appraisals. Why should you not be bound by them?
A couple of responses, Your Honor, and thank you for raising that. First, I'd like to point out that the detailed analysis that we suddenly get from defendants about these inventory appraisals only occurs in their reply brief, and we think it's a new issue on reply. But setting that aside, two important points. The first is that 2022 appraisal that they say is in the quote-unquote record, and I'll get to why it's not a record in a second, that's not actually an appraisal. That's a 2-page letter, and the court will search in vain for the actual 2022 appraisal. It's not in what they call the record, and I'm not going to refer to what it actually says because it's dehors the record. With respect to the 2023 and 2024 appraisals, which are in the quote-unquote record, I think this is all, by the way, absolutely factual and outside the scope of a motion to dismiss, but I'll address it. What those appraisals actually say is that there were issues with inventory, and I direct the court to for example, the 2023 appraisal, which notes—
Do me a favor and lower that mic, bring it closer to you so that I can really amplify your voice. Go ahead.
Thank you. I direct the court to page 731 of the record, which is the 2023 appraisal, which does note that there are issues with the inventory. But again, Your Honors, this is not a record. These are factual discussions. And from the discussion we've just been having, it sounds like it's a motion for summary judgment. It isn't. This is a motion to dismiss. On a motion to dismiss, unless the documentary evidence utterly refutes the allegations or creates a defense as a matter of law, it's not susceptible to dismissal under 3211A. I also want to respond briefly to the point about the receiver. The receiver was in place for about 11 weeks before we filed the amended complaint.
Were they open to the receiver when she first went to the office?
No, Your Honor, and that actually goes in part to our breach claim because they actually resisted giving her full access to the documents. That's one of the allegations in the complaint.
Specifically the Schweizer's Bank of America account.
Exactly, Your Honor.
What did the receiver find?
Well, we allege actually in the amended complaint that there were numerous issues with the company, and actually this is one of the reasons, as Your Honor pointed out earlier, that this amended complaint is different from what the court was considering at attachment. This amended complaint does include substantial allegations related to alter ego relationships, including what the receiver found, which was that personnel at Schweizer didn't know that they worked for Schweizer as opposed to the RSG companies.
Was there too much, your friend indicated there was too much reliance on like group pleading for that purpose. How do you respond to that?
Sure, thank you for raising that, Your Honor. I'd point the court to, I think it's paragraph 2 of the complaint, which points out that the RSG companies are a highly intertwined web of entities. In other words, they don't operate like separate companies. So defendants now saying that at the motion to dismiss stage, we need to be more specific within our allegations is missing the point, because the entire allegation is that this is a web of companies that is operated like one company. So there's no way to distinguish them because they aren't really operated separately. That's the allegation. And again, on a motion to dismiss, that should be taken as true. So with respect to the sophisticated, the fact that we're a sophisticated entity, yes, we did diligence, already addressed the appraisals, but I also want to point out that we bargained for the ability to rely on representations made by the companies. That's at section 3.14 of the credit agreement. And this court has said repeatedly that when parties, including sophisticated parties, bargain for the right to rely on representations made in the course of diligence, then you can't later say, well, you can't plead fraudulent inducement because, actually it turns out there was fraud. Of course, sophisticated parties can bring fraud claims, and that's exactly what we're doing here. Lastly, I think there was a brief reference to transfers and how the transfers were all explained. As I said, they've tried to throw in nearly 1,000 pages of what they call record evidence into what they call the record. Of course, we contest what's in those documents. They don't actually address all the transfers we talk about in the complaint, including at paragraph 158 of the complaint. This came up in the court below. But in any event, because this is a motion to dismiss, we get to test those allegations through actual discovery. Not, discovery has been proceeding, of course, after this motion was argued, but none of that is reflected in the curated, self-selected, quote-unquote record that the defendants have put in.
Would the damages be the same for fraud and breach of contract?
Well, Your Honor, I think the breach of contract actually includes the fee shifting provision, among other things, but I'll note that in our brief at the bottom of page 31 and 32, we cite a number of cases where this court has repeatedly held that even when damages are the same at the motion to dismiss stage, you can plead fraudulent inducement and a breach of contract in parallel, and we'll note that they don't apply to any of those cases, and I think that's just clearly the law of this division.
So assuming we have to consider whether your fraud claims are duplicative of your breach of contract claims, what do you have to say about that?
They're not, Your Honor, and the test is whether or not the fraud has to do with misrepresentations of present fact or future facts and future representations in a contract. Here, the misrepresentations we allege have to do with, for example, the value of the inventory. That's a present fact, and this court has repeatedly held that when you are fraudulently induced into a contract, those representations, those false representations, are necessarily collateral to the contract. Of course they are. They precede the contract. So the claims are not duplicative.
Anything else? No?
Thank you, Your Honor.
Okay, you have 2 minutes. Let me
Thank you, Your Honor.
set the clock for you. Give me a second.
I should just get started. Look, they are clearly duplicative, these claims. The fact that it's $30 million for every single one is indicative that it is duplicative. Of course, there are cases that say there are certain circumstances where it's not duplicative, but it is a very strong indicator that they are duplicative. And
Well,
when I
at
think
this stage, we have repeatedly held that a party can assert these claims side by side at this stage.
you have on certain instances, on other instances, you have found that they are duplicative. So there are case by
So
case.
tell me why here it's duplicative.
Well, because it's not just the $30 million, right? If you look at a number of the allegations, what they are talking about are breaches of the loan documents that they wrap into their fraud claim. The only exception, and I will agree with my colleague over here, is the fraudulent inducement claim that they make, which is not separately enumerated as a cause of action, but that's of no moment. So the fraudulent inducement claim, though, is based solely on the alleged inventory fraud, which is why the inventory fraud is so important. And that's why I think you really have to look at their own internal allegations. They say there was no reduction in the inventory. I mean, there's a number of allegations in here that they make that in some respects are a little strange for a plaintiff to make. I mean, for example, a lot of their accounting fraud theory is based on conduct that never happened. So what they talk about are this financial information that was false, but they talk about a non-party, Michael Farr and Wendy Kellum, if you'll recall, and they specifically say in their own complaint, they refuse to share that information with the plaintiffs. So we're talking about non-events. The other thing I really want to point out, Your Honors, is particularity. There is no particularity in this complaint. I implore you, F-searched the names of each of these defendants through the complaint. There is not an allegation of a single statement by Mr. Nerie to anyone. There is not a single allegation of any statement by Mr. Horton to any plaintiffs. All they allege is that he spoke to Mr. Farr, non-party, Ms. Kellum, non-party, and that they refused to do things that he allegedly asked them to do.
Thank you.
Thank you, Your Honors.
Salas versus New York Presbyterian Hospital. Justice Rosado is recused from this case. Should there be a tie, the court will employ its rules to vouch in another judge. You may proceed.
Good afternoon. May it please the court. Alejandra Gill of Heidel, Petoni, Murphy, and Bach for New York Presbyterian Hospital. Your Honors, the issues on this appeal are very simple. This is a medical malpractice case where the defendant submitted expert testimony establishing that there were no deviations from the standard of care.
Well, let's talk about that expert affidavit.
Yes, Your
Did
Honor.
that meet the prima facie burden?
It did, Your
Because
Honor.
seemed very conclusory to me.
Your Honor,
And I'm only speaking for myself now.
I understand. Dr. Gross, who is the expert in this case, opined that Dr. Iyer properly performed the placement of the ICD. That's the procedure at issue. He specifically said that the technique used to gain access to the heart was the appropriate technique. He described how the cephalic vein is located between the pectoralis and deltoid, and that there's a low complication rate by proceeding in this manner. He also opined that the doctor properly and successfully introduced the sheaths and then advanced a defibrillator lead into the right ventricular apex. He further opined that after performing the procedure, the doctor ensured that the leads were properly placed by checking the pacing and sensing thresholds, and lead stability and stimulation, threshold and sensing. He went through the procedure. He opined that there was nothing to suggest that there was cannulation of the artery. He said that all appropriate imaging modalities were utilized. He testified that there was...
We read it, and I'm telling you, I found it to be conclusory. I did not think it met the prima facie burden. So in my mind, there was nothing wrong with the way that plaintiffs responded.
Well, Your Honor, respectfully, our position is that it was not conclusory. He went through details of the procedure, how it was performed, and how the complication, had it occurred during the procedure, there would have been signs of it. And he talked about that,
Does
stating...
he explain why this patient ended up 7 days later, 6 days later, in the condition he was in, with the findings that he had?
Your Honor, he does posit some possibilities as to how the injury occurred. He said that one could not absolutely exclude that there was an irritation from the procedure that he performed, but he also opined that it was possible that the tamponade was a delayed result of myocardial or vascular injury resulting from a cardiac catheterization, which he did not perform. That was performed days before Dr. Iyer's procedure. But he also opined that a more cogent argument was
That this would have happened because he doesn't, the plaintiff doesn't start showing serious signs of a problem until the 13th. So you're saying something that happened even further away is the cause of this?
Possibly, Your Honor.
And what did he say to support that? This possibly doesn't,
Well, Your Honor,
that meets the burden?
Dr. Gross met the burden as to a deviation from the standard of care, opining that there wasn't. At that point, plaintiffs had to rebut those opinions with expert opinion. They didn't. If plaintiff had rebutted those opinions, then of course we would look at whether we satisfied as to proximate cause.
I agree with you that they would have to rebut the doctor's opinion if it reached prima facie. That's the standard, and so long as that's where you have to meet.
Your Honor, I completely agree. However, obviously the disagreement is whether we met that burden.
Yeah.
And it is our position that our expert's affirmation certainly met the burden. He also talked about how if the complication had occurred, the injury had occurred during the procedure that Dr. Iyer performed, there would have been signs either immediately during the procedure or immediately after, and here there were none, as Your Honor already pointed out. It was days later that he had some sign of an injury. So it is our position that Dr. Gross certainly met the burden for us as to a deviation from the standard of care. He did not have to meet the burden as to proximate cause. We met the first burden. Plaintiff failed to rebut it by submitting any expert opinion. Further, the lower court, actually what the lower court found was that our expert conceded that the procedure was performed improperly. That certainly was not something that our expert opined. He never said that the procedure was improperly performed by our doctors. So our argument is that the lower court erred in finding that our own expert conceded a deviation from the standard of care. Thank you, Your Honor.
Thank you.
If it please the court, Mark Cambereri from Sobo and Sobo for the plaintiff respondent, Cesar Salas.
Now, for the benefit of my colleagues, because I'm not speaking for them, why do you believe that the defendants did not meet their prima facie burden? And what failings are there in their experts' affidavit that would relieve your side from submitting an expert affidavit in opposition?
Well, let me digress to what is the defect here that caused the injury, caused the bleeding into the tamponade, into the heart. The defect was not this acute injury from this procedure. In other words, the devices didn't puncture the inside of the heart valve and cause immediate bleeding, an acute injury. This was a subacute injury. It was a mild irritation. The doctor calls it, one cannot absolutely exclude subclinical, subacute myocardial irritation, he calls it. That's what the defect is. And that's what he says was the problem. And that's what he says may have been caused by the procedure. So that's, once he says all this, he's essentially given me what the defect is, and he says it was caused by this procedure, or he can't rule it out. He says that there was a catheterization. The chronology is, he's admitted on the 24th of January. According to the reply brief, there was a catheterization on February 4th. And then on February 7th, there's this procedure by Dr. Ayler, the defendant. And then on the 14th, the tamponade occurs. So
Dr. Gross is uncertain as to what caused this. Is that right? The
yeah,
expert's uncertain.
Well, yes, he's uncertain. He says, he doesn't rule out that it could have been caused by the tamponade. And he says, so he then says, well, there could have been some prior, pericardial thing, but there was nothing proven there. He also says, well, if there was a defect, then I could say that. But then, there was a defect. I pointed that out in my brief at page 7 and 8, that in the medical record, there is an effusion that's found post-operative or post this tamponade proceedings and getting rid of the blood. They look at the heart again and they say, oh, there's this effusion here that's occurred. It's small, but that's what it was. So he doesn't address that. And so to me, that's a question of fact. Was the defect there or wasn't it there? He says, maybe it wasn't there. That's about all he says, but I've said, well, there it is in the medical chart, and you're not saying anywhere where there was no defect, Dr. Gross. So to me, Dr. Gross never met his burden of proof to say there was no defect, there was no issue, and that defect, that procedure absolutely did not cause this. Moreover, he doesn't say that the procedure, even if the procedure did cause this defect, it wouldn't be medical malpractice. He didn't even say the even if thing. So, I got him.
Well,
and the whole thing.
I will say to you, counsel, you're taking a big risk by not submitting your own affirmation.
Well,
and so you kind of live or die on that decision.
I just do motions and appeals. I didn't know Cesar Salas. I didn't know there was a file named Cesar.
I'm just saying, I can't recall in my literary years here seeing a med mal opposition by plaintiff without a medical expert's affidavit. I'm just saying.
I had a case where there was
I don't need to hear about your war stories, okay? I thank you. Do you have anything else you wish to argue?
you know, that when I send an affirmation to an expert, I'd send it to them in Word after giving them everything, after discussions, and they make the changes. They put in anything they want. He addressed a lot of these things and said, there's no causation there, and there's no defect there, and there's no problem there. But when he came to this, he didn't give the attorney the magic words.
Thank you. Counsel?
Briefly, Your Honors, you asked counsel to articulate exactly how our expert didn't meet the burden, and he didn't answer your question. The bottom line is they didn't submit expert testimony. They didn't establish what about our expert affirmation was deficient. And here
Was
they...
it that it was equivocal or wasn't with sufficient, it didn't rule out with sufficient certainty other possible causes of the plaintiff's alleged injuries?
Right, but that, again, is just going to proximate cause. So in their papers and their motion and here on argument, they're focusing on the proximate cause, ignoring the fact that they didn't establish a deviation from the standard of care. And this court has held in DeChico v. Roberts and Edmond v. Albert Einstein Hospital that once we establish that there's no deviations from the standard of care, the expert is not required to opine definitively as to causation. So again, we met our burden as to departure from the standard of care. Plaintiff offered no expert testimony, and the arguments as to proximate cause should not have defeated the summary judgment motion. Thank you.
Certain underwriters at Lloyd's versus Southwest Marine and General. Please give my colleague a moment to return.
Good
Well
afternoon.
accounted for. You may proceed.
Thank you, Your Honor. Please the court, Stephen Weiner, O'Toole Scrivo, appellant, Southwest Marine and General Insurance Company. My case is not as exciting as a medical malpractice case. We're talking about insurance and contracts. I'm going to start, make my points in probably what may seem like a reverse logical order, because I'm going to start with the pleadings here. Because if you look at the contracts and you ultimately have to look at the pleadings to decide whether the contract, whether a duty to insure is triggered. And I call this out in my papers.
Well, there's two different issues, right? A duty to defend and a duty to insure, and one is broader than the other, correct?
Absolutely, Your Honor.
Okay.
And we're only here, this appeal only concerns the duty to defend, because it's been our position, and I don't think my adversary would disagree. A duty to indemnify may or may not exist, but it's going to be a function of what gets determined down
Happens
the
at
road.
the trial, right.
Thank you. So I have the third-party complaint here. So what was a bit anomalous about this fact pattern is our insured, which was on target, no, JGR, I apologize. I have two cases on today. JGR.
Happens to be all the time.
They were not sued in the underlying case. Right. So what the insured for Underwriters did, Arsenal, they attached the complaint to a third-party complaint. They said if the accident happened the way it was pled, then it's due to your negligence. And they're asserting that that triggers the duty to defend here. And my position is there's no allegation that our insured did anything wrong. They're certainly not in the underlying pleading, which they have attached. And then they say, you know, I'm actually reading from, there's two third-party complaints, but they're identical. And this is page 249 in the record, paragraph 14, that if the plaintiff was caused damages as alleged in the complaint through negligence other than plaintiff's own negligence, recklessness or carelessness, then the damages were sustained due to the negligent, careless, and reckless acts of omission or commission of JGR. And that is the pleading. And so what the judge below was stuck with that pleading. And the other point, a big point I want to make on this argument here is that what the judge did to determine, she went outside the pleadings to try to determine what did the pleadings actually mean. And so she went outside the pleadings, which is problematic under the Fitzpatrick case. Not that you can never do it, but the court's been pretty clear that you're not trying the underlying case.
I thought that the standard for, with regard to the duty of an insurer to defend, It's ensured arises whenever the allegations within the four corners of the underlying complaint potentially give rise to a covered claim, right?
Yes, I agree.
So the question is whether these facts, they don't have to prove liability. That's not what you're arguing, right?
They don't have,
In their pleadings, they don't have to assert, we think X was negligent, just that the facts giving rise to the complaint could be seen as covering that particular party. Isn't that what the standard is?
absolutely, I agree.
Okay.
And that,
And counsel, Judge Chan speaking over here, the duty to defend would be bigger than the duty to indemnify. So the two underlying injured plaintiffs claimed that they were injured when they fell from the scaffold, and the scaffolding company was hired by your client.
that's respectfully, Judge, that's not what the record shows. That we don't know who hired the scaffolding company. My client put up a sidewalk shed. We have an affidavit in the record by my client, which is not rebutted by Underwriters, that we had nothing to do with the scaffolding, and referring to the plaintiffs, the underlying plaintiffs, both of them, they're a verified bill of particulars. They have attached photographs, there are statements, multiple statements that they were working for another contractor, that they were injured on, they weren't injured on the sidewalk shed that my client was responsible for. So what's happened here is,
So were there additional scaffolds aside from that first level sidewalk shed?
yes,
And did they extend from the sidewalk shed so that they were one continuous scaffold around the building? Right, because a sidewalk shed usually is narrower, less wide than the entire scaffold that may surround a building that's under construction, right?
that could be correct depending upon the construction. And I
Right.
don't know all the fine details of this particular construction.
Okay.
There are photographs in the record and they show what my client did, and the plaintiffs in the verified bill of particulars provided photographs of where they were injured, and and we have an affidavit from JGR saying.
You're saying the photographs that the plaintiffs have provided are not photographs of your client's sidewalk shed?
Correct, absolutely.
And that any other scaffold that was erected had nothing to do with your client?
That's what we're saying, and that's what to me, look, I'm an advocate. It seems clear to me that that's not fairly disputable. If I could make this argument, but it would probably take about 30 minutes to make it, which I don't have. But it looks like the company that responsible for the scaffolding was probably a company called APS, and there are documents in the record that seem to identify it, and that was a company hired by the general contractor, not by my client. And we get sued because we have insurance. We were, I can't speak for Arsenal and know what counsel had as a litigation plan, but we are an insured contractor that was on the job. It's just that our work had nothing to do with the injuries, and both plaintiffs seem to agree. And of course, it's not evidential.
It's not unusual, though. You know that, right? That on a construction site, they sue everybody on the site and they figure it out later. But you'll have time on rebuttal, okay? Counsel.
May it please the court, Matt Ronan from Kenny Shelton for the plaintiff respondent Underwriters. I'd like to first just very quickly address the three things that opposing counsel said, one legal, one factual. The first is that when deciding the duty to defend, a court does get to look outside the complaint, but only to bring something within the duty to defend. That's Fitzpatrick. It's been around for 30-some years. It's the law of the land in the state. And the court says we look at the complaint, we look at extrinsic evidence, extrinsic known facts to decide a duty to defend. Fitzpatrick also says we cannot look at extrinsic facts to find no duty to defend. So that's the legal point. Real quick, factually, a sidewalk shed is scaffolding. I cited cases in the brief from this court, among others.
Was there another contractor on site that was doing sidewalk sheds or scaffolding?
So Arsenal, and this was the third point I was going to bring up, which is Arsenal was hired to do sidewalk sheds. There's an affirmation in the record, unrebutted, from Arsenal's president that says everything we were hired to do, we subcontracted to JGR, right? Everything we were hired to do went to JGR. We didn't do anything ourselves. Not only that, we didn't hire anybody else. 100% of it, JGR, right? And so the mere fact that Arsenal was alleged by the underlying plaintiffs directly to have caused the accident, that Arsenal's work was the cause of the accident by Salas and Tapia, inherently means they're alleging that JGR's work caused the accident because JGR did all of Arsenal's work, right? With respect to the record, I know it was mentioned a bill of particulars. It actually was not a bill of particulars. It was a production of photographs in response to combined document demands. In any event, those photographs produced by the underlying plaintiffs do show, let's call them non-sidewalk shed scaffolding equipment. Go to the next few pages. What do you see? You see sidewalk sheds. So if the argument is that the mere fact that the underlying plaintiffs showed pictures of these other scaffolds means it must have been that equipment that caused the accident, the plaintiff also showed pictures of the sidewalk sheds that JGR erected, which inherently means that must raise the possibility, and again, there's coverage if JGR was even a 1% cause of the accident. There's a duty to defend if there's even a possibility that JGR could have been a 1% cause of the accident. And one final thing here.
It says, has actual knowledge of facts establishing a reasonable possibility of coverage.
Correct, which Arsenal's been sued directly. JGR did Arsenal's work. That's the end. With respect to the third-party complaints, they're standard fare for third-party complaints. Arsenal can't very well say, I know that JGR caused this accident, when Arsenal is also trying to defend a case, and JGR did all of Arsenal's work. That would be tantamount to saying, I caused the accident, which defendants tend not to do in their pleadings. The final point I'll make, there are two third-party complaints. Yes, one by Arsenal, but one by Talbot, the owner. Talbot, independently, not insured by Underwriters, alleges that JGR caused the accident. If there's anything else, I'll be happy to answer it. Otherwise, I will be finished.
Thank you.
Thank you.
So you have 2 minutes.
I don't think I'll need that long, but thank you. I just want to say, for a third-party complaint being standard fare, I don't know what standard fare is, but this is the third-party complaint that we have. And so my argument is based on that exact document. And again, I'm back to my argument that there is no allegation against our insured. I also would just like to point out, it's a convenient argument to say, Arsenal says, JGR did all our work, so if we're being sued, it must be because of JGR's fault in some way. If you look at, and it's at page 199 in the record, it's a amended verified complaint of Salas, but the other plaintiff's complaint is identical. Starting on page 200 in the record, going to 201 and 202 and 203 are approximately 15 separate, and 204, more than 20 separately numbered paragraphs of all the things that Arsenal is alleged to have done wrong, and only one of them is contractor. There are numerous capacities, and the Arsenal affidavit doesn't cover most of those. That's all I have, Your Honor. Thank you.
Thank you so much.
Make a request. I have another matter on the calendar. It's my only other matter. Would it be possible that?
I can't call you out. Had you made that request early, I could have entertained it. Where are you on the calendar?
It's about 4 or 5 more cases down. I'll enjoy sitting here listening.
All right. Thank you. DLO Securities litigation. You may proceed, sir.
Good afternoon, Your Honors. May it please the court, Joshua Baker with the Rosen Law Firm for the plaintiffs' appellants. So this case is on a motion to dismiss claims brought under Section 11 of the Securities Act on behalf of investors in the June 2021 IPO of DLO. And Section 11 imposes strict liability for misleading statements or omissions in IPO documents. And under Section 11, there are certain facts that companies are required to disclose, including known material trends that affecting their business at the time of the IPO. Here, plaintiffs allege that DLocal failed to disclose two critical trends that were impacting its business at the time of the IPO. First, there was a major shift in the company's business the year before the IPO. Second, because
What reflected that major shift? What information or document reflected that?
that would be, eventually that was revealed to the market by a report by Muddy Waters in 2022, and plaintiffs also had corroborating allegations from their own investigation in the complaint showing the same thing. And what
Does that in any way, shape, or form relate to the take rate?
Yes, this is about the take rates.
Okay, so was the information in the offering materials, that underlying information about profits, losses, revenues, et cetera, wasn't that information sort of viewed as superior to any information provided by the take rate?
I'm not sure what was considered superior, but it's important to sort of identify there's these two trends here. What first happened, there was a shift in 2020 from DLocal's biggest customers that went to this much lower margin business, where before they had margins of about 4 or 5%. By margins, I mean, I'm referring to the take rates here. It's a little easier to conceptualize as margin. It's how much money DLocal made on each dollar of transaction volume. So the first trend was a shift from these major customers, including its biggest sole customer, to this really minuscule margin business. They went from 4 or 5% margins to margins as low as 0.1 to 0.3%. That's a big difference, and that's a big deal.
How did those impact the plaintiffs here?
The plaintiffs are investors in the IPO, and
I
so
know
what
that, From what I see on the record is that they did all right.
they did very much
they didn't-
not all right.
What?
The IPO was at $21, and after the truth came out, the stock is trading at less than half of that, and it hasn't recovered to this day. It lost 50% of its the trading price on the stock from the IPO price, and that's damages is way down the line.
Because it must be another case then. Go ahead. keep
Okay.
talking.
But yes, these are critical things to investors. It's important to
How
know.
long did it last, that decrease of how long was that going on for?
How
Was
long
it consistent, or was it just a few months? How long was the decrease?
the decrease in the stock price? It dropped immediately, I think, on the day after the report came out.
Take rate decreases.
The take rate decreases. Okay. They started, as we allege, it peaked in second quarter of 2020, which is a year before the IPO, and then each quarter after that, it dropped severely, much steeper than what was actually disclosed in the cherry-picked quarters that were actually in the offering documents. Ignoring the fact that these quarters that would have showed a much steeper decline, which for much more recent periods to the IPO itself, were known, they were completed, they had that data, they knew what their own top-line financial results were, they disclosed it for other periods, they obviously knew what those take rates were during those periods that
The
they
crux
chose
of your
not to
complaint
disclose.
is that there was a violation of the Securities Act because in the lead up to the IPO, they didn't disclose the take rates.
Correct. They didn't disclose the shift in business that caused these take rates. The shift in business towards much lower take rates by their biggest customers, and that caused their overall company take rates to fall much, much faster than what they portrayed.
And what in Section 11 or what controlling authority could you cite to us to support imposing that duty on them with respect to their offering material?
So the duty, yes, Your Honor, the duty is under Item 5 of Form 20F, SEC Form 20F. It's essentially equivalent, there's no dispute here on the legal standard, to Item 303 of Regulation SK, and that says that you have to disclose certain things, including known material trends. And the case law is also very clear that if you fail to disclose information required by Item 5 or Item 303, that is a misleading omission in violation of Section 11.
Is there any case law you're familiar with interpreting Section 3 and or Section 5 to include take rates?
Actually, yes, Your Honor. There's a very recent case that I wanted to bring to this court's attention. The decision came down just a couple weeks ago after the briefing was concluded here. This is a case in the Southern District of New York.
Would have been helpful had you sent that to us before.
I agree, and I regret the oversight, but I think it's important to highlight this case.
Oversight?
To the court.
Probably important to disclose all material information.
Hello.
Well taken, Your Honor. But if I may, I think this point is directly on point. It's remarkably similar to this one, and on that case, the motion to dismiss was denied. The case is Pacella, Pacella v. Hesai Group, Hesai. The case number 24CV876, and I have the Westlaw site. It appears it will be published, but hasn't been published in the Federal Reporter yet. The Westlaw citation is 2026 WL 458135. And this is from Judge McMahon in the Southern District. And the
So
facts are
it is instructive, but not binding on this.
correct. It's not binding, but it's remarkably similar. So in that case, it's also a Section 11 case alleging undisclosed trends under Item 5, just like here, against a Chinese company that makes LiDAR products for cars. In that case, the company disclosed that its margins had fallen. It disclosed that they were going to fall more in the future, and it disclosed that those declining margins were due to a shift towards a new lower margin product line. But what they did not disclose was that the margins for the new product line were over 10 times lower than what the company had historically enjoyed on their margins. Judge McMahon found that that was sufficient to allege an undisclosed known material trend, and it was actionable under Item 5 and Section 11. So there, even though the company had disclosed that margins were decreasing, the IPO documents were misleading because they didn't disclose the severity of the decrease and the huge margin disparity, which is exactly what we have here, except here there were even less disclosures of the falling margins, and there was no disclosure at all of the shift by DLO's clients to the lower margin business.
Thank you. You'll have time on rebuttal.
Thank you, Your Honor. May it please the court, Antonio Perez Marquez, Davis Polk and Wardwell for DLOcal.
Was I off about the numbers here?
Well, you were off about the numbers. The stock price decline is accurate as reported by my colleague. The key thing there is
Profit.
the profit. The profits were going up steadily throughout the pre-IPO
And
period.
isn't that what
what-
investors care about?
That is what investors care about.
How
Your
much
Honor.
money I'm getting in my pocket from the investment?
100% correct, Your Honor. Revenues going up.
I thought I was crazy.
Revenues
Glad that
going
you
up,
corrected
profits are going up, transaction volumes going up. That's what investors care about. They are focused on this metric that they've plucked out of thin air, take rates, not something the company even talks about, not one of its key business metrics. And it's the myopic focus on a plaintiff-selected rate
I
metric.
want to be clear, right? The gross profits and the TPV amounts with revenue increasing from almost 18 million in Q1 2020 to over 59 million in Q2 2021 when the IPO occurred. And then over 118 million in Q4 2022.
All accurate,
And I
Your
could
Honor.
keep on going on.
All
in
accurate.
terms of the profits that kept on going up.
All accurate, Your
Okay.
Honor. More and more and more profits coming in. And that's why this case, one of the reasons this case has no merit whatsoever. Let's be clear on what this case is. This lawsuit was prompted by a short seller report. That's someone who's trying to drive down the price of the stock. The lawsuits followed. Some of them filed in New York State court. They abandoned virtually the entirety of what's in the short seller report. They abandoned on this appeal most of what they argued to the court below. They're now down to this take rates issue, which it doesn't work for several reasons. First of all, as Your Honor was just explaining, the idea that it reflects a problem with the company that investors would have cared about is just made up. There are no well-pled allegations that would support that. And to Your Honor's question of where does this come from, the changing mix, they hemmed and hawed a little bit in answering that question, because where it comes from is just parroted quotes, allegations from the short seller report. And the courts, Judge Engelmeyer has a very good explanation of this in the In Re DraftKings decision, where he explains why lawyers can't do that. Allegations that are just taken from a short seller report, quotes from anonymous, unidentified witnesses with whom plaintiff's counsel has not spoken, those allegations are not well pled. So this whole idea, to your question of where does this idea of the changing mix, a problem with the business come from? It's just from the short seller report. It's not well pled. The person they spoke to, the only confidential witness, former employee 3, all he or she said is the management sometimes talked about take rates in meetings. That's it, period.
Could the take rate or a take rate reflect on a registrant's financial condition or operation?
Not really, Your Honor. And the reason is because there are different ways a company can be successful. You could be a car company. You can sell a few cars and make a lot of money on each one. You can sell a lot of cars and make a little money on each one. Either one of those is totally valid and a totally reasonable path to success. And the company was crystal clear as to which one of those it was pursuing. We are focused on growing volume. They never once said, the strength of our business is our great take rate. What makes us successful is our margin. And the reason I emphasize that is that distinguishes all the cases they cite, including the one they just mentioned for the first time, which I didn't even know about before today. But from what my colleague described, he made the key concession. The company had talked about their margins. And once they talk about their margins, then yes, you have to tell the whole truth. But my client never said anything about take rates. And so you look at Erie v. NN, which they say is controlling, the case they just described to the court, France v. Jayin, St. John v. Kluper, all the cases they rely on, they all involve undisclosed trends or risks in a metric or in a part of the business that the company had talked about and held out as important. They say, yeah, well,
In the offering materials.
exactly. And once you do that, you know, if the company had said the key to the reason you should invest is our great take rate, we would be having a different argument. But that's never,
Because you would have an ongoing obligation to bring your investors up to speed on any changes.
yes, because you have to, once you have to speak completely.
Right.
But here the company didn't speak at all, and there's no freestanding obligation to disclose take rates. It's not a GAAP metric. They haven't pointed to any accounting standard or any securities regulation that would require disclosing it. Even the items they point to in Rule 20F or in Form 20F, those don't do it either, because what those say is you must disclose trends that that the issuer reasonably expects will have a material unfavorable impact on revenues or income. There's no allegations here that would support a view that the take rates fit that description. With respect to risks, what has to be disclosed is the most significant risks that make an investment risky. There's no allegations that would support taking that view of take rates in this case. And I want to direct the court, to the extent anyone did care about take rates, it's undisputed that, again, take rates are just a ratio. Revenue or profits in the numerator and transaction volume in the denominator. All those metrics, what you need to calculate take rates, it's undisputed, it was disclosed, and it was disclosed accurately. And if I could direct the court to record page 626, it's a very important page because we graphed there what any investor would have seen if they cared about take rates, if they wanted to see how is take rate evolving. And what it shows from the disclosed numbers is the decline. The take rates had come down a bit. And now they say, aha, but the problem is you didn't disclose the intervening quarters. And what the court will see when it looks at record page 626 is that what actually happened is that take rates shot up. They went up almost 30% in the case of gross take rates in Q2 of 2020. And then they gradually drifted back down to a normal level. So the idea that this is, some steep or sharp or persistent decline, that's not what the data shows at all. What the data shows is it's fluctuating. It went up and it came back down. And there's no basis for them to allege that management knew or should have known, even should have known, that it was going to continue going down versus go up.
If one was interested, could he or she, taking the information that was provided in the offering materials, tabulate the rates?
Absolutely. And that, in their words, you could easily calculate it. It is simple and obvious from the accurately disclosed numbers. And to go back where we started, those accurately disclosed numbers, the metrics that go into take rates, revenue, profits, transaction volumes. That's what investors care about. All of that was disclosed, and it's undisputed that it was disclosed accurately.
Thank you.
Thank you.
Counsel, you have 2 minutes.
Thank you. I want to very briefly clear up a couple things that my colleague over here said, which were not really didn't accurately characterize things. He said that these take rates are plucked out of thin air. First of all, that's not true. This is something that defendants reported themselves as soon as the IPO was over. In the next 3 earnings calls, they said, "Here's our take rates. Here's how much it changed." The analysts were asking about the take rates because investors want to know. This is something they care about. It is revenues and profits. It's not how much total volume are you processing, it's how much money are you actually making off of that volume. And then he also mentioned that the allegations about the shift came only from the short report. That's not true at all. The COO of the company made his own comments in those same earnings calls saying, yeah, this is what caused take rates to fall. It was this shift towards this much lower margin business. We also don't just have one former employee confidential witness in the complaint. There are other ones too, which corroborate this shift, which my colleague did not mention at all. The allegations that these take rates were disclosed or easily calculable, yeah, only for the periods that they cherry picked and chose to disclose. There was no way that an investor could see what the second quarter, third quarter, fourth quarter, or the ongoing quarter at the time of the IPO, what those numbers actually were. And the numbers didn't just drift down, they fell 7 times faster. You can make this nice chart, but if you look, this is what they showed, this is what was happening in the year before the IPO. And so I think the more central point that I want to address that Your Honor was asking earlier, essentially, why do investors care? Why does it matter? They care. The bottom line, which I tried to answer the first time, was the stock price dropped, which is an indication of how much this information mattered to investors. But why do they care about the take rate specifically? They want to know about the company's growth prospects. Tons of sale volume is one way to do it, but that's only half the story. This isn't some unicorn tech company where the plan is grow and scale and build users, and then you figure out how to monetize it later. DLOcal was selling a service in a competitive market, so investors cared about how much they were actually making from the volume. Falling take rates meant them less money on every dollar that they processed, which fundamentally—
allow you to finish your thought, but
Yes.
you're out of time.
So that fundamentally changes the picture of the growth story and how attractive it is to investors. If you go from 5 to 100, and then 100 to 105, 110, yeah, profits are still going up, but that's a big difference in the rate that it's increasing, and that's what this case is about.
Thank you.
Could you just repeat that Westlaw site?
Yes.
That Southern District case?
That is 2026 WL 458135.
Thank you.
And again, I apologize for not bringing that to the court's attention
Not only
earlier. And
not
if
to this court, but to your adversary, that's not, just not cool.
I understand,
Okay.
and if the court wants
It's
to give an
inappropriate.
opportunity
You
to
should put your adversary on notice. You know better.
understand.
Thank you. Estate of Margaret Kainer versus Christie's. Oh, I'm sorry, you're right. My apologies, I called you out. I've done this to you twice. I don't know why. They're next. You'll be up next, okay? Sorry. I did it again. My apologies. Warerki versus Bronx Community Board. You may proceed.
Your Honor, may it please the court, my name is Aaron Gladstone. I represent the petitioner appellant Jeremy Warerki in this matter. This case centers around one diligent civil servant attempting to do his job while facing a campaign of harassment and retaliation from his direct supervisors. I'd like to use my time before you today to focus on 2 issues: the timeline of events as found by the ALJ, and how the ALJ's decision regarding petitioner's retaliation claim, as adopted by the respondent division, results in a legally absurd conclusion. I'd also like to note that the thrust of petitioner's appeal does not require this court to modify any of the factual determinations made by the ALJ. And those
You
would be
can just substitute our decision for the ALJ? Really? Under what case law is that permissible?
I'm sorry.
We are bound. I mean, our opening for changing an arbitration, right, result.
I'm sorry.
Article 78 proceeding. These proceedings are not easy to overturn, right? You know that.
Correct.
So you're saying you don't have to change the factual, any of the findings of fact, just change the conclusion of in the proceeding below.
That's
right?
correct.
And you think you've met your burden to do that on these facts? Where your client was twice promoted after? I mean, I don't see how the arbitrators, how the decision of of the Division of Human Rights, runs afoul of what came before them. I really don't. Explain to me how someone who
Absolutely.
gets promotions, even after what he's complaining of, is still.
Absolutely. I just want to note this was not an arbitration.
Yes.
It just,
I
okay.
misspoke, Article 78. Go ahead.
But I appreciate the question. The conclusion reached by the ALJ is essentially that if an employer post-complaint does something good for an employee, it excuses any retaliatory measures it takes against an employee.
But what retaliatory measures were taken against him? Tell me.
The second round of performance evaluations that were predicated on basically excusing.
So it's impossible that after his bad first evaluation that he did better, so that the next evaluation was correspondingly better. That's not possible.
That's just not what happened because.
But that's what was found, right?
I don't believe that's what was found. I believe what was found was that in response to the complaint, the employer sought to institute a second round of evaluations.
That's what the ruling said?
I think the ruling does not.
Or is that your interpretation of the ruling?
That's certainly my interpretation.
That's not what the ruling said.
I don't think the ruling characterizes the motivation for the second round of evaluations one way or the other.
Right. So you're editorializing and you want us to accept that editorialization.
Correct.
Right.
And if I may, the thrust then of the logic of the ALJ's decision, again, is that if this is a guidepost on how to retaliate against an employee. If you retaliate against an employee and then do something nice for them, however many months after the fact, it would excuse the retaliatory conduct of your supervisor. That's plainly not what the law says. That's not the bill decision from the Second Department, which is very clear.
Counsel, didn't your client also file a complaint with the borough president's office?
He did.
And what was the outcome of that complaint?
I think the record reflects it was dismissed or otherwise closed administratively. But the subsequent agency that took a look at this complaint found enough facts to warrant a hearing. So again, my point being is that the Billick standard is very clear. Your employer cannot take adverse actions that would dissuade a reasonable worker from making or supporting a charge of discrimination. That's the operative standard. It is not necessarily that they did something nice for him or granted him a promotion or granted him a raise after a complaint. It's about the conduct taken by the employer in response to the complaint that is germane for a retaliation claim. I'm happy to answer any other questions, but the appellant will rest on his brief, specifically on the appeals as regards to hostile work environment, but I, of course, would answer any questions about that or any part of the record.
Thank you.
Good afternoon, Your Honors, and may it please the court. I'm Alan Racinez. I represent the city respondent. Your Honors, my colleague on the other side, Mr. Gladstone, is just doing his job and saying that there was some sort of a constant campaign of harassment here, but respectfully.
Well, what was the adverse employment action thrown at him after he filed his complaint?
I mean, he has two things he suggests. One is that the first round of evaluations were somehow tainted by that, or at least perhaps. I don't quite know if he's saying that or not, but of course that's not possible because that round occurred in February 2019, and the initial complaint to the Bronx Borough President was not until March of 2019. And then he also seems to be saying that the second round of evaluations in May of 2019 were retaliatory. But I guess he's saying two things. One is just the fact that they were done was retaliatory, and the other is maybe that their substance was retaliatory. And again, the latter point.
That in the 9 months after he filed his discrimination petition, he received better evaluations and 2 raises.
I agree with you, Your Honor. That's a big part of our case, and that's what the ALJ found, and we think that shouldn't be disturbed by this court on substantial evidence review.
Were there any legitimate concerns about his work performance?
Yes, there were many, Your Honors, and I mean, I don't want to belabor the point because I know Your Honors have read the briefs in the record, but they included productivity problems, lack of engagement in community outreach, lack of punctuality.
They changed his work schedule.
Yes.
Which he admitted that he's not really good at getting to work on time.
Yes, Your Honor.
And that continued to be the case even after they changed his start time in order to accommodate his needs with his children.
That's right, Your Honor. And yes, that's right. They offered to help him with that, and I think there were still issues. Certainly, they offered to
He
help
was
him.
still getting there late after they changed his time to 10 a.m.
I think that's right, Your Honor. I don't remember. I know that he definitely had to change the time. Certainly,
And a major role of the district manager is community engagement, correct?
that's a major role. He supervised the office of the community board. So absolutely, Your Honor, and there's no dispute on that. I don't think. Another thing he admitted to, Your Honor, as far as his work performance issues were when it may have been Vitaliano, I forget, but someone commented to him that he had a problem with things piling up on his desk, and as a result, not getting to things because they were buried under his piles of paper. He admitted that he was a hoarder. So there were problems here that he himself admitted, and there were other problems that many members of the board shared, even if he didn't expressly admit them. And so the other thing, to return to your question, Your Honor, about the retaliation, he seems to suggest that the fact that the additional round of the May 2019 round of evaluations was in retaliation for the March filing. But there's no evidence in the record for causation on that at all, Your Honors. And it's his burden to prove, and it's also substantial evidence review, which means if there's any evidence in the record to support the ALJ's finding, it should not be disturbed. And here there is evidence to support it. If you look at page 774 of the record, the conversation that Warerki and Vitaliano had, Vitaliano said, "Look, we're gonna review you for calendar year 2018." This was in January 2019, and he said also, if your performance doesn't improve, we're going to do interim evaluations. So one can infer that if anything, that the May evaluation was an interim evaluation. Is that it's not clear either way for certain, but there's certainly zero evidence that my colleague can point to that it was a retaliatory action, that the reason for the second round of evaluations was the March 2019 filing of the complaint to the Bronx Borough President. Zero evidence that I have ever seen in this record or that my colleague has pointed to. Thank you, Your Honors.
Counsel, you have 1 minute.
Some very brief points. I would also urge the court's attention to page 774. This is the employer supervisor admitting that he doesn't know how to do employee evaluations because, as the record reflects, these were unprecedented, meaning that we can infer, as argued, that they were a result of the supervisor's discriminatory beliefs around caregiving. And I just want to note,
Or the need for extra supervision of your client.
I
If you have a worker who is habitually late, you change their schedule to accommodate their needs, and they're still late. Seems to me like this person needs to be watched and
I agree.
monitored, right?
Disciplined, monitored, spoken to, but performance evaluation is different.
So we get to choose how they do it.
If it is no, but you get to determine if it was motivated by a discriminatory animus, and that would be unlawful.
Okay.
The other point, another point raised. Actually, no, I'm happy to sit down. Thank you.
All right. Thank you. Estate of Margaret Kainer versus Christie, Inc. I hope so too. Your clock has started. I just want you to know. I want you to know your clock has started.
Your Honor, Jerry Krause, representing the plaintiffs. The first thing I need to tell this court is that last week, Congress passed the HERE Act of 2025, which directly impacts this case. It was passed by unanimous consent by both houses. It's still awaiting signature by the president. What it does is
So it's not in effect until that signature is done, and we get to see what the effective date is.
That's correct.
So why don't you continue with your arguments, and this is the record.
Yes, but the point of, it does.
Counsel, it's to horse the record. Please argue what's in your papers.
You're welcome. I will. The basis of this appeal is to vacate a stay that's been in effect in this case for 8 years. And there's two reasons to vacate it. One is that Christie's, by its actions and admissions, has basically acknowledged the sole issue on which the stay was based. And secondly, the interest of justice. This is a 2013 case. We have not gotten to square one. We have not gotten any discovery. We have gotten nothing. 3 plaintiffs have died. It's a problem. The court below did not even address the waiver and estoppel point. Essentially, what is the basis for the waiver and estoppel is my clients are the heirs to a collection of 400 paintings. And this court recognized when it approved the stay that there's only going to be one determination, if it ever comes to be a determination in the Switch court, which is you are the heirs to everything. They're not going to do a painting by painting analysis. And what Christie's did was, fully knowing that there is another claimant out there who, by the way, in the interim, their certificate of inheritance has been annulled by a German court. They knew that the ownership issues with this painting were identical to the ownership issues with the painting that they sold. Yet they sold that painting and wrote and told the bidding public with no reservations, my clients are the heirs to the Kainers, and there are no other claims out there. They knew that the same claim that they're saying is preventing them from having to answer this lawsuit was pending. And it was the same claim pending against that painting as pending against this painting.
Let's assume there was no stay.
I'm sorry?
Let's assume there was no stay, or that the standing issue was either resolved in your favor or was never brought up. What would this case look like? What issues are going to have to be tried?
The issues that need to be tried are that my clients said that Christie's, when they sold the painting, they sold it as restituted to sham heirs, to a different group. And it's our position that there was public information. They should have known that they had no claim to the to be the heirs. They weren't even real people. They were a foundation, and we're saying that Christie's negligently failed, did a blind eye. There was actually something on the internet which basically said that the claimants were settling a litigation in Switzerland because everybody knew that the plaintiff really died in France, and so all these other people didn't really have a claim to it. So we're saying Christie's never should have sold this painting, and as restituted to the heirs, by the heir that they restituted to was a fake foundation. And by doing so, they actually legitimized the painting. They put it into the stream of commerce in New York. To this day, we don't know where that painting is, and it's only because they legitimized it and marketed it that they could do that. So we're suing Christie's for conversion. We're also seeking—
I'm sorry to interrupt you, but so there are significant material issues besides standing that have to be litigated. Is that what you're saying?
Oh, absolutely. I mean, there's significant discovery that needs to be.
Okay.
Standing doesn't need to be litigated because we have certificates of
Is there any reason why we could, why it would be inappropriate to lift the stay so far as allowing the case to proceed to discovery at least, so that once the Switzerland action is moved one way or the other, at the very least, you're not starting from scratch 4 or 5 years down the line whenever they decide to decide their case?
We would welcome that. But the issue, the other issue, which you didn't want to hear about, is that will have to come up if the legislation is signed, because this stay was issued on a form non-convenience.
Not that I don't want to hear about it. Don't say it that way.
Okay.
I am not supposed to, and this court is not supposed to consider something that's not in the record. So
I made a motion yesterday to expand the record.
Well, I don't have that motion.
But I
okay?
did because it was just passed last week. But I did make a motion.
I need you to appreciate the confines of the court.
I do.
Okay? So, you know, what you just said casts an aspersion on me.
Not at all.
You didn't want to hear it.
Oh, no, I just
Well,
didn't.
that's an aspersion on me
No, 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 I
personally,
apologize.
okay?
That was
Just-
not what, that's not what I meant. but
Yeah, well, I mean, that's what you said for the entire world to hear. And it is recorded forever on YouTube. Thank you very much.
I only was trying to,
Look, I want you to advocate for your client, and I understand your frustration. If I had to wait 8 years on a stay and there's no movement in another jurisdiction, I would feel the same way you do, okay?
No,
But that doesn't mean that it's our fault.
I wasn't
Okay,
suggesting that
all
it
right.
was, and if in any way,
As soon as
apologize.
it's signed, trust me, we will read it, okay? Counsel, we will hear you now.
Good afternoon, Your Honors. May it please the court, Joseph Patella on behalf of Respondent Christie's. Your Honors, the trial court imposed the stay for one and only one reason. There are pending foreign proceedings that will specifically determine whether appellants even have standing to pursue this action.
Well, is there a question that they are the heirs of the family? Is there any question about that?
From the familial standpoint, there is not. What is
Okay.
being litigated in Switzerland.
Okay, so we know that they are, at least by familial connection, they arguably have standing. And so the issues then are what?
Well, let me clarify. There is a family connection between the appellants and Margaret Kainer as to who is entitled to own the vast assets of the estate, which include over 400 paintings. That's still an open question.
I understand that. That's why there's an action in Switzerland, right?
Exactly.
I got that.
And to Your Honor's point, the suggestion about allowing this case to proceed, at least on discovery, there would be significant prejudice to Christie's if that happened.
Why?
Well,
what prejudice? Besides money.
Okay, well, certainly.
Besides having to pay for a lawyer to conduct discovery, what's your prejudice?
Beyond that, it is something that this court itself previously identified when it first affirmed.
Yes, but that was 8 years ago.
Okay.
So at some point, the Swiss court has to do something because we can't just sit here and wait. How much longer should we wait?
We should wait until
another 10 years?
Yes, Your Honor, and I'll tell you why.
It may be useful. It may be
I will tell you,
useful.
but there is a reason why, and I'm gonna use this own court's decision why.
It may be useful for the remainder of the time to operate under the assumption that some of us are not, believe that our colleagues 6 years ago believed there would have been resolution in Switzerland. So we have an open mind.
That is fair. And I think the concern here still remains that a premature lifting of the stay risks inconsistent and competing judicial outcomes.
No, not if all we're doing is discovery. So if we lift the stay for the purposes of conducting discovery, that does not run afoul or any danger of competing decisions, because all we would say, presumably, is go and do discovery. And worst case scenario, you will have spent money for discovery for no reason. That's the worst thing that could happen.
It does force my client to be litigating a case that could potentially be moot depending on the outcome.
So we should wait 10 years for the other jurors. You said 10 years. You said 10 years. So we should wait 10 years for them to come with a decision and say, yes, they have standing, and then we should do discovery after 18 years.
What's important to remember here is that the party that has control of the foreign proceedings are the appellants. They're the parties in
No,
the
they
case.
clearly don't, because trust me, if the appellants had control of the proceedings, they'd have a decision by now.
The trial court in affirming the stay, maintaining the stay, the reason why we're here today.
Years ago.
No, I'm talking about the order in which we're here today, that was just recently granted.
Right.
The trial court said on the record on page 5, quote, that the Swiss proceeding is taken in an inordinately long time, should be addressed in that forum. Indeed, their own Swiss counsel, Your Honors, confirmed that the Swiss proceedings are in the, quote, investigation stage, after which the Swiss court will set the final pleading hearing. That's on the record on page 531. This directly contradicts the appellant's alarmist claim that there may never be a hearing on the merits.
It's 6 years and they're still in the investigative stage?
Your Honor, we're not parties to the case. We are complete strangers.
I'm not blaming you, but I have a litigant who is standing still. And there is no end in sight.
That's on the litigant, though. That is their case.
That's not on the litigant, that's on the court.
Respectfully, if you are litigating a case, you want to advance it to get an outcome. Again,
And sometimes you can, and sometimes you can. I don't know what the opposers are doing to prevent there from being a decision. The same games that get played in New York courts, I'm sure are played in Swiss courts. I don't think we're unique in that regard.
Christie shouldn't be held responsible for that. They are strangers to
Neither
that.
should the plaintiff.
When was the painting sold?
The painting was sold back
2009?
Yes.
And did Christie's receive a commission for selling that painting?
I believe so, Your Honor, yes.
Okay. And this work was confiscated in 1933 in or around?
It is, the allegation is that it was one of the works that was looted during World War II by the Nazis. Yes, Your Honor.
Can you just quickly address counsel's argument that the fact that Christie's acknowledged when the Pizarro painting was auctioned their rights, that would impact on this Degas painting?
Yes.
They've already been a concession?
No, there hasn't. And appellants are mistaken. Appellants like to put a lot of reliance on the sales notice that Christie's issued at the time of selling the Pizarro. But that notice related only to the Pizarro by its express language, stating in pertinent part, quote,
Because you had information that somehow the owners of that piece were different from the owners of the Degas piece?
no, Your Honor. When the Pizarro work was presented, Christie's merely facilitated the sale. The Pizarro work was presented to Christie's as an outcome of a litigation that took place in Georgia between the current possessors of the Pizarro and the appellants. They jointly came to Christie's to resolve that dispute by bringing it to auction. So the appellants were just as aware as Christie's about the foreign proceedings. Christie's merely facilitated it. They acted within the confines of the agreement, which afforded them various protections to sell the work, and did sell the work to a buyer who is also afforded protections under Christie's conditions of sale. As the trial court said, the appellants have it backwards. The evidentiary value, to the extent any exists on the Pizarro, needs to be used by the Swiss Foundation, used against the Swiss Foundation in the foreign proceedings. As the trial court said, I know my time is up, but just to note what the trial court said in connection with this most recent order. I'm not talking about the original stay order. The trial court said, quote, whatever Christie's might have said or not said concerning the ownership of a different painting is merely potential evidence in the Swiss proceeding. It all comes back to that case. That case needs to be litigated first before we can continue in New York. Thank you, Your Honors.
I'd like to ask you, go back to one question that was asked earlier, and just want to circle back to it. What is the prejudice to Christie's if the stay was lifted for the purpose of engaging in and hopefully completing discovery?
I don't want to minimize the significance of what goes into a litigation and the expenses that take place. I understand Your Honor's point, but certainly Christie's should not be forced to litigate against the plaintiff, to take depositions against someone that might eventually not be the plaintiff in the case. There's significant prejudice in that. And again,
There's no prejudice in that other than money. If you have not said anything, not one word that tells me there is actual substantive prejudice other than your time and your money.
if the foreign proceedings rule in favor of the Swiss Foundation,
Right?
then
Then the discovery would have been for naught. That's all.
exactly.
That's all. So we're talking money and time. That's it. Thank you.
Thank you, Your Honor.
You have time.
Yeah, a couple of points I want to make. First of all, the basis of our motion was actually a little broader than just lifting the stay, because one of the things we're asking for is that by admitting that we're the owner, that issue is out of the case. Christie's has waived any right to ownership and standing. Whatever happens in the Swiss court is irrelevant because they've already acknowledged our ownership.
Could you inform us as to what diligence has been used in Switzerland to push that case to a resolution?
They have been pushing and pushing and pushing. Part of the problem is plaintiffs keep dying, and every time they die, they have to go through probate proceedings. Then they have to substitute them into the cases. And and in fact, there are so many procedural motions in Switzerland that it may never reach a decision on the merits. And that's one of the reasons we brought the case here, because Swiss law is not what U.S. law is in terms of the HERE Act requiring cases to be heard on the merits. But but if we are correct that Christie's, by acknowledging our ownership in connection with the painting under identical circumstances, when it was in their interest to get a commission on to sell it, they said, no problem that the foundation has a claim out there. But now, for 8 years, we can't litigate our case because the foundation has a claim out there. Our real claim is that they have now waived their defense that we don't have standing or ownership. And with that waiver, that undercuts the whole reason for the stay. But that also but by having that waived, there's no risk of contradictory decisions. They've essentially conceded that we have standing and we have ownership rights in this case, in this painting, because that's exactly what they said and they told the world. So
Thank you. Riley versus Memorial Sloan Kettering. Okay, who's going first? Okay. And just tell me who you represent, okay? All right, you may proceed.
Good afternoon, Your Honors. My name is Michael Kivert. I'm here with Ropers Majeski on behalf of JGN Construction.
Bring that mic up.
Yes, ma'am. I filed the first appeal, and it was limited to the court below's ruling on the 241-6 claim pursuant to 23-1.7D, as in David. Our argument is that the staircase here that was used to provide access to a job site is not a passageway or other working surface within the meaning of the provision unless it is the sole means of access. The court below...
Well, I think that to argue that this was not seems to be outrageous on its face, because then what you are arguing is that these workers should have exposed themselves through a hospital wing at the height of COVID. That is not a viable alternative means of egress.
It was
That is not, I mean, really? We are going to say, yeah, use that staircase where you're safe from medical exposure, or use this staircase where you are playing Russian roulette with your life.
I believe the idea, Your Honor, was to protect patients from the workers, not to protect workers from the patients.
Really?
That was my...
We had people dying by the dozens during that time. So it's not just protecting the patients who clearly were also compromised, very much so, but you don't want to contaminate workers getting COVID from walking through the hallway.
I understand that.
Right?
Yet we have photographs showing at least one worker using that
The fact that they did it doesn't mean that it's right. So you want to keep arguing this? Go right ahead.
The rule, I just want to make it clear to the court, the rule at the time was that for the COVID screening in the morning, they were required to use this stairway to enter and exit the building. After that, during the day, there was the alternative entryway, which is shown in the photographs. It was used, it had a blue mat in front of it, all of those things.
Because the blue mat was going to protect you from airborne viruses.
Certainly not.
Okay.
Does the court have any further questions?
Counsel, I'm a little confused. You said that they didn't go through the hospital stairways for the good of the patients in the hospital.
Right. The idea was to not potentially expose the patients to the workers.
So doesn't that lend to the fact that this was the only means of egress then for this plaintiff? What you just said?
Not according to the testimony that's on the record. That it physically existed and they were explicitly allowed to use it. That was the testimony. It came from the foreman, the plaintiff's own foreman.
Would the circumstances then suggest a tribal issue of fact as to whether that the passageway in which the plaintiff was injured was, for all intents and purposes, the only means of ingress and egress for the workers?
I don't think so. You have the Golubiowski case decided in 2024 in the New York County Supreme Court, which basically said, here are photos showing the alternative ways in. That's good enough. That shows us that this is not a passageway. It was not the sole means of access.
There's a bunch of other cases that say the opposite, but that's okay. Next.
May it please the court, my name is Scott Singer. I represent the plaintiff, respondent, appellant in this action.
Oh, you shouldn't be next. The defendant should be next.
Okay. I just did.
You're last.
You're last.
Good afternoon, Your Honors, and may it please the court. Elliot Hamilton, of Lewis Bristwas, representing MSK. I'm just going to start off with the labor law 240 subsection 1 claim. This was a permanent staircase. This was not pursuant to this court's decision in Ryan v. Morse Diesel.
How about the Silva versus Toll, where we said, contrary to defendant's assertion, permanent staircases are not categorically excluded from labor law 240 sub 1 coverage, and that is a First Department 2024 case.
I would suggest that with some of these other cases that there are. Again, I would submit that each of those particular cases have different circumstances within them. There were other cases as well that people like the Santana case and the Cross case, which plaintiff ended up relying upon, were
like the Gomez versus Sandy Clarkson case, a 2023 case that also found that a staircase is a safety device on the 240 sub 1. So we have a lot of cases, right? So the question is, what is it about the facts of this case that make it fall outside or inside our precedents?
I would say that in this, the question is more of the permanence, not just the permanence, but also the character of whether it's actually attached to the building. A lot of these, and there are circumstances, and while this court has definitely pointed out circumstances that, again, I'm not sure.
I mean, is MLK, I got that right?
MSK, Your Honor, sorry.
MSK. MSK isn't arguing that stairwell through the hospital during the height of COVID was a proper way to go in and out, right?
I mean,
I can't imagine that a hospital like MSK would, one, with their patients, so it was a dual thing. You don't want patients who are being treated for cancer and are super highly compromised, right? Being exposed to anyone who could potentially bring COVID and then, create a complete fatal and terminal situation, right?
And that's to the point of why, and that's to the point regarding my friend's point regarding 246. I'm choosing not to. I see where your honor is going with that. I would just on that front, I would just say that some of the cases are a little bit inapplicable because there was uncontradicted testimony with respect to Tolk. But here we have the two. There was contradicted testimony on that, and so it's inapplicable. But I think then the last point that I'll make, and I'll reserve the rest of it for my reply, is on the labor law 200 point. Our position is that that plaintiff is relying most on on speculation for the idea that that somehow the MSK as the owner had some sort of constructive notice as to the condition there when it was JGN that was responsible for actually responsible for the cleanup of there. And there was testimony that was brought forth on pages 339 and 341 of the record that indicated that there were workers that had been there cleaning for about a 2 to 3 hour time. So
that is not, like, there's at least evidence there to suggest that there was some there was information that it was addressed and that there was some constructive notice, possibly with GGM, but not necessarily with MSK, and that plaintiff relied primarily, if not entirely, on speculation, which this court has held in Marte, Berger, and Pinto to not be sufficient, and his reliance on Second Department case law to the contrary is against exactly what this court has held before. So I'll save the rest for a reply.
You don't have any to say, but you'll have a minute on rebuttal. You're next.
Good try.
The red light means you ran out of time, so you didn't have any extra. Thank you so much. It's all right. Go ahead.
Good afternoon. May it please the court. My name is Joel Merchant from Manning, Gross, and Massenburg on behalf of third-party defendant and respondent ADCO. In this one, just to be clear, this one, we're a little bit different situated in this one. We're not a main party. So this one is specifically in regards to our cross motion, which we made to dismiss several parts of the third-party complaint JGN made against us. So just to the court is on the same page as me, I'm trying to establish that I think there are some undisputed facts, and from those, I think we can therefore establish that the contractual claim and then subsequent the common law indemnification and contribution claims can be dismissed. So going to those facts real quick, Your Honor, as we were just hearing from co-counsel in this case, it's a permanent staircase. There's no dispute on that. This accident, where it happened, was not actually part of the job site itself, and specifically in regards to where, yes, Your Honor, it doesn't have to be, but it's not where work was being done. It's not where ADCO was supervising any work or whatnot. This can become relevant to the points I'm gonna make, but we would posit from that, Your Honor, that because it was outside of the job site, it was outside of ADCO's scope of their work at the time that this happened. So in regards going now to the contractual claims itself, we look at the contract. And as Your Honor, the court probably knows, the record, the relevant part of that is section 7.1, which is in the record 1021 in pages 1022. There are two specific parts to that contract that I think are very relevant. One, I'll go to the second one first, which is specifically that it says that JGN can basically not pass off their own liability. We know that that's common rule of court, so there's no issue there. The next one is what we would call the trigger language to that, and it is specifically that it says it must be arising out of, in connection with, or as a result of, or consequence of the performance with work of the subcontractor, in this case ADCO, under their agreement. So what we're proposing, Your Honor, this one is the issue here is simply put, there is no situation under these fact pattern where ADCO could be found at fault. That ADCO, that it was, ADCO wasn't supervising this person at the time. They weren't working, they were going off on a coffee break. They had left the job site where work was being done. Yes, it was still in the building or whatnot, but what we're saying is under the circumstance of this fact pattern, there may be a dispute as far as whether or not JGN had any responsibility to monitor that. There's no dispute that ADCO was responsible or was overseeing anything that was happening on that staircase. So because of that, we'd say that there can be no contractual finding against ADCO, so the contractual contribution claim should be dismissed. I'm gonna now move on, I guess, to the common law indemnification claims briefly. Your Honor, as the courts know in this one, again, so I apologize for that. Common law indemnification and contribution, they generally stem from vicarious liability on this one. So again, Your Honor, I'm going to point you back to those facts that I said before, and I believe it clearly establishes that this was not happening during the scope of ADCO's work.
You know, you keep saying that, but we have case law that we have case law where liability was found where a worker is walking into the job site. So he hasn't even started working. So the fact that he is not doing work at the time is not the criteria. That's not the point upon which we make our decision.
I understand that, Your Honor, but I would respectfully say that the record here.
So he was still on duty. The fact that he was going down those stairs for a coffee break doesn't mean that he doesn't get covered if the site is not safe. So.
Okay, Your Honor, I'll respond in my reply. Thank you.
Now you go.
I was just following the briefing order. It's a little confusing, a lot of parties here. Just want to refer briefly to this 200 issue. There was testimony we cited in our brief, deposition testimony of Andreas Severus from JGN, who explained that there were house plumbers working in the area at the time. Those were MSK employees that were working there. So they clearly had notice, or they should have had notice of the conditions. And MSK offered nothing in the way of proof of notice. So there's a question of fact as to whether they're subject to liability under Labor Law Section 200. To get to the juicier questions, I'm going to not deal with the 240 case law because Judge Manson, you already alluded to many of the cases there. But I want to mention something about the 241 Sex 23.1.7D. This morning I found another case. It's one that you're familiar with, Ward against the Times Square hotel owner. And it turns out that in that case, the Supreme Court in this decision cited the Potenzo and Tolk decisions, both of which are discussed in my brief. There were 3 external hoists that were available to the workers who needed to access the 14th floor. The plaintiff was descending on a stairway instead of taking those. There were multiple ways that he could have accessed his work area. He slipped on an icy surface of the stairway, and Supreme Court found it was a violation of 23.1.7D, citing, as I said, Potenzo and Tolk, 2 appellate division decisions, and it was affirmed by this court. The decision was affirmed. So there was liability, despite the fact that there were multiple ways. It wasn't the sole means of access. And as you've pointed out in great detail, there was only one proper way of going about this that didn't jeopardize the health of these very, very sick patients or the workers who were presumably in healthy conditions and were subject to COVID. There was only one way of doing it. The Potenzo case, the Tolk case, the Ward case both reiterate a passageway is within the meaning of 23.1.7 if it was the way the workers generally accessed the work area. That's the situation here. That was the way they did it. That's the way they were supposed to do it. And most of them were very compliant with that entirely reasonable restriction. There's no question that this is exactly the type of situation where the plaintiff was acting properly.
Didn't JGN Superintendent Severus testify that the east staircase where the plaintiff fell was the preferred means of egress and that everybody there knew it?
Yes, everybody. Well, yes, everybody knew it, and they did it for a very good reason, as the court is fully aware. It was the primary entranceway to the construction site, according to Mr. Severus. It was the preferred means of egress, according to his testimony again. So he was doing everything that he should have done. There was dirt on the stairway. It was an old stairway. It was a slipping hazard. It was also, even though doesn't come to mind as a tripping hazard, the language of 23.1.7e applies because 23.1.7e specifically applies to dirt and debris. So if there's dirt and debris, the court has said on many occasions, even if a worker slips, it could still be governed by the tripping hazard regulation, 23.1.7e.
What about the missing treads on the stairs? The missing treads on the stairs?
That's also a slipping and a tripping hazard, I believe. And that was, yes, that was clearly there. And apparently they were worn so much you could see right through to the tread. It was a dangerous condition.
So if I can take you to 240 sub 1 for a second.
Yes.
Our law, the Gorey and the progeny of Gorey, found that 240 sub 1 is applicable to permanent stairwells where that stairwell was the sole means of the workers' ingress and egress from the work area. Is there a tribal issue of fact here as to whether this stairway was the sole means of access?
Well, as I said, the cases I cited are all 23.1.7d. It also uses the same standard, sole means of access, but the court has really not followed that standard in a situation like this where there's a preferred way of doing it. So I would say, no, there's not a question of fact, that it's that 240 sub 1 was violated and 241.6 was violated based on the violations of 23.1.7D, 23.1.7E, and also 23.1.7F, which requires that you have a safe stairway or ladder connecting different elevations of the work area. I believe all three were implicated. And as I said, the case law is all set out pretty well, and I think in my brief.
Okay,
Thank you very much, Your Honor.
All right, 1 minute.
It's hard to know where to start.
Well, you got 1 minute.
Well, yes, I understand that. Potenzo, plaintiff slipped on an outdoor path the court called a walkway because it was outdoors. Walkways are outdoors. The word is escaping me. Passageways are indoors, right? You can't, as I understand the law, take a case that was about a walkway outdoors with ice and then go back to
Well, one of the cases cited was a fall on ice on a staircase. That the staircase was not completely closed, so it was a permanent staircase but open to the elements.
Yes, that's my understanding as well. But you also have for the 240 claim. Hold on.
I'm going to give you another 30 seconds. You have already run
I'm
out of
sorry.
time.
I'm sorry. Okay, on the 240 claim, you have the Serrano case, First Department 2017. Accumulation of paint chips and dust on a platform on which plaintiff was working, which is not the case here, was one of the usual and ordinary dangers at a construction site to which the extraordinary protections of Labor Law 240 do not extend.
Okay.
Okay?
So now the staircase is a work area?
No.
Because you've just cited a case that says that dirt and debris in a work area is not, well, you said earlier that it wasn't.
It was allegedly, and I stand by that, but it was allegedly tracked out from the work area, which was up the stairs and through a door. Okay?
Okay. All right, you're out of time. Thank you. We've got your arguments. Next, 1 minute.
I'll just be brief, Your Honor. Again, regarding Labor Law 200, yes, that Samaras may have ended up saying that he ended up seeing plumbers, plumbers that may have been hired by our client beforehand, but that doesn't. But there's still a lot of layers of supposition in terms of whether there's no information whether the plumbers were there that day or there's no information that plaintiff can establish that the dust was visible or apparent, that the condition
You
was there.
moved for summary judgment.
Yes, we did.
You had to establish, not the plaintiff.
Well, we would say
You had to establish the absence of it. Have you?
we would say that we did because we established. I'd submit that based on our briefs that we did end up doing so, and yes, I would say that, and I just rest on our briefs.
Thank you.
Thank you, Your Honors.
You got 1 minute.
Thank you, Your Honors. If I can just try to address your point of, yes, the plaintiff is entitled to recovery. That's why we have the labor law. The issue here before this court today is not whether or not, because plaintiff doesn't have a direct action against ADCO. The issue here, as far as we are concerned,
Third party.
exactly, is whether or not there is any way under which JGN can recover against us. And we posit based on our briefs and our papers that we can't do that because, again, of those facts that we raised before you that these other parties have also talked about. The last thing I want to just raise in the few moments that I have left, the one case that JGN did bring up in regards to this claim that you can still be working outside the thing was this Bronx case, Marine v. Pinnacle Demolition and Environmental Service Groups. It's in the briefing papers. We addressed in the reply as well. But, Your Honor, it's a clearly distinguishable case. I mean, it's obviously not binding on this court because it's from a lower court, but more importantly, it's a very distinguishable case. In that case, it was alleged that someone was coming back from work, but when they were injured, they were potentially doing their work at the time. That's not what's here before the court. So thank you, Your Honor.
Thank you. Counsel, you have 2 minutes.
Yeah, I don't think I'm going to take it unless you have questions for me.
No, I think we're good.
I just wanted to point out that the case that what was the case that you were on, that was the Ward case, where it was an indoor out. It was a stairway that was indoors, but it was exposed to the element, and that's how it got icy. So,
Remember,
if there's no questions, thank you.
No, there's no sir reply here. Thank you, have a good day. Travelers Indemnity versus Southwest Marine and General. I like that. I haven't seen that ever. You may proceed.
May it please the court, Lisa Stefanski for the Travelers Indemnity Company of America. Your Honors, the trial court correctly determined that Southwest Marine has a duty to defend 181 and CM in connection with the underlying personal injury action brought by Joel Pichardo. However, the trial court erred in making two additional determinations, the first of which was that determining the priority of coverages owed to these additional insureds vis-a-vis the Southwest policy and the Travelers policy would be premature. Now, in making this holding, the court ruled that it couldn't determine the priority of coverage because of the theoretical existence of potential other coverage available to these additional insureds, and those policies that might also afford coverage to these additional insureds were not in the record. This evinces a fundamental misunderstanding of the relief the Travelers sought when it made its motion. To be clear, Travelers sought a declaration that Southwest's policy was primary to Travelers' policy, and that Travelers' policy was excess to Southwest policy with respect to these additional insureds. What the underlying court seemed to understand that to mean was that Travelers was seeking a declaration that Southwest coverage to these additional insureds comes first in line. That's not what primary means. With respect to insurance coverage, primary simply means earlier, excess simply means later. Primary does not necessarily mean first in line. So the fact that Travelers sought a declaration that Southwest coverage was primary to Travelers doesn't necessarily mean that Southwest is first in line
Except that there have been determinations where that exact language is used, and that's exactly what it means. Primary is first, excess is second. I mean, that's...
Primary is earlier, excess is later. Primary is not necessarily first, because there may be multiple excess layers, for instance, Your Honor. Maybe there are 8 layers of coverage.
And maybe there may be several insurance companies who think that one should be primary, right?
Exactly.
So how can the court make a determination on that issue without having all of the world of insurance that touches this case?
The court can determine the priority of coverage vis-a-vis however many policies are before it. That
But
does
why do it when you don't have all of the policies before you?
Your Honor,
why should the court be forced to make a partial decision based on only what they have in front of them when they know there are others? That's not for you to decide, that's for the court to decide.
Well,
what's wrong about that?
Let me draw one distinction between what the trial court did here. The trial court did not affirmatively state that there is other insurance available.
She said there could be, and she doesn't know.
Exactly. So
Right.
this is hypothetical. But even if the trial court was positive that there was other insurance available to these additional insureds that wasn't in the record, there may not be an issue as to the priority of coverage owed under the policies. There's a dispute between the carriers before the court, and requiring all of the policies that afford coverage to a particular insured to be before the court in order for the court to determine the priority of coverage owed between 2 policies where the carriers are sparring would frankly result in an absurdity where carriers that are not disputing their priority of coverage where they are in the chain have to be dragged into court in order to put their policies in the record.
So I'm sorry to cut you off. It's in my nature as a judge. What is your second issue?
The second issue, Your Honor, is the second way that the trial court erred was in holding that the endurance policy does not afford coverage to these additional insureds because of that policy's sub-limited coverage exclusion. Now, that holding was based on the court's determination sua sponte that Southwest coverage to these additional insureds was limited to $1 million rather than
Party
the
agrees, your adversary agrees with you on that, correct?
Exactly. So because that determination should be vacated, then the subsequent determination that the endurance policy does not afford coverage should also be vacated. Those determinations rise and fall together. If the court has no further questions,
Wait a minute, which two decisions?
the determination that the endurance policy does not apply to these additional insureds, and the determination that the determination that Southwest Marine's coverage to these additional insureds was somehow sublimited. Exactly.
Okay, all right, thank you.
Thank you.
We'll have time on rebuttal.
Good afternoon, Your Honors. Stephen Weiner for Southwest Marine again. On that sublimit issue, I mean, we agree with travelers that the issue of policy limits was in brief below, and the trial court addressed it sua sponte. So I don't think that warrants any further comment on my part. Priority coverage, we obviously agree with the judge below, and I just think the approach suggested by my colleague invites piecemeal litigation and just an endless morass of coverage litigation, suits, parallel suits, just clogging up the courts. I mean, let's get it all dealt with in one proceeding, and I think that's ideal.
Have additional insurance parties been brought in?
Not
yet.
to my knowledge. I don't believe so, actually.
All right.
I mean, my colleague didn't bring it up in oral argument, but it is in their submissions that no written contract was required below. I mean, the court below ruled on the basis of a written contract, and Travelers has not taken an appeal of that part of the ruling, where the judge ruled in their favor that my client had a duty to defend 181 and CM based upon her analysis of the contract. So I submit they really are ill-positioned to argue that there's no written contract required. And of course, I think a fair reading of our policy does require a written contract, and at page 283 in the record, I have that's where our endorsement appears, and it actually says, if coverage provided to the additional insured is required by a contract, et cetera. No one's arguing that that's not in the policy. And there's also another endorsement, which is in the record, and it's in the record at page 344, where it specifically talks about designated construction projects, and it says, every single designated construction project for which you're obligated by a written contract to maintain general liability insurance, and then it talks about the conditions on which the insurance will be offered. So they're talking about a contract, not just in the endorsement at 283, but also in this other endorsement at page 344. And by the way, and the endorsement at 344 also says the limit is $1 million in this situation. We argued extensively about how ambiguous the contract was, and the fact that Travelers had to go substantially outside the four corners of the contract to try to convince the court that the court should rule in their favor. With all the deposition excerpts that they put in on the motion practice, I think is evidential that even they concede that this is a confusing, very, very ambiguous contract, which requires a lot of explanation. We briefed what we believe are the flaws in the contract, so I'm not going to waste the court's time and repeat all that, what's in my brief. I'll certainly entertain any questions. All right, thank you.
One final point on the priority of coverage, Your Honor. The trial court's ruling in that regard was based on a misreading, essentially, of the Court of Appeals holding in BP air conditioning, which held that in order to determine the priority of coverage, a court must review, quote, all of the relevant insurance policies at issue, end quote. So the court did not determine or did not hold that a court determining the priority of coverage must review all of the policies which afford coverage to an insured in a particular scenario. Again, that would yield an absurd result where insurance carriers that are not in dispute and are not fighting about the priority of their coverages would be hauled into court just for the purpose of putting policies in the record
On
unnecessarily.
the underlying labor law case, I'm assuming that case is still going on?
It is.
And based on what I can surmise from these papers, there are a bunch of parties.
There are.
And by virtue of that, a bunch of insurance contracts.
Correct.
Okay. Thank you. Reyes versus Height Construction. You may proceed.
Good afternoon. May it please the court, Brian Kalman on behalf of the appellant, third-party defendant, Everest. It is uncontested by all parties that in order to have a contract, you need an offer, acceptance, and consideration. It is also uncontested that there was no additional consideration for this document that Height relies upon. In fact, this court recently, last year, decided in 3604 Jerome LLC, NYC Health and Hospitals Corp., decided a similar case to this. In that case, there was an indemnity provision in a lease that said it is triggered by use of the premises. An easement was not part of the definition of the premises. Later, the defendant, or the party that was supposed to indemnify the other, accepted the indemnity agreement, and this court said there was no consideration to make that a new contract. This is the same situation here. Everest entered into a contract with Height. Height owed Everest indemnity. There was no obligation by Everest. And then a year later or months later, Height tries to make them sign a document, which they did. It was a pro forma document for any contracts going forward. Therefore, there was no consideration. It's conceded. Therefore, there was no contract.
So you use the term pro forma contract. What's that?
Sure. As Height actually said, they usually, standard operating procedure, would circulate the same indemnity provision and insurance procurement that they would do every year.
Whose obligation is it to read it and make sure that the terms in this new agreement are the same?
No, no, no.
Signing, no?
This was not a scope of work document. It was simply an indemnity document.
I
Or an insurance?
understand.
Yes.
And he signed it.
He signed it, uncontested.
Okay.
But what's not there is any consideration for the additional promise and New York General Obligations Law
As I
5-1105.
understand it, they, in order to continue working, they had to sign that. That's not true?
That's not what they said.
No?
No. Actually, what they actually said is, and Jimmy Downs testified to it, he thought it'd be for prospective jobs, not anything retro. But I'm not, based upon the evidence in this record and the law, in order for the past consideration to be used for that document signed in January of 2026, what they should have done, Height, if they wanted it to be applied, is to say, all the consideration we gave you for the other contract and the scope of work, that's the consideration here. They didn't do it. And under New York General Obligations 5-1105, that is fatal to their claim. There is no contract. And with the last thing that I did have, though, they make it, well, you got a blanket additional insured endorsement on your contract. You know what? They do it every time. What it needs is a contract underlying it to be able to trigger the insurance policy. It's of no consequence. Thank you very much.
May it please the court, Patrick Lawless for the respondent Height. This wasn't a separate agreement. Both parties, Mr. Downs and Mr. Height, both testified because they had an existing business relationship that this was a common practice that every year, because there was work, ongoing work, every year there would be this type of indemnification, blanket indemnification agreement that would be signed by the parties that would apply to the work going forward. So it's not a completely new contract. It's not a new agreement. It is supplemental to every existing agreements.
Clear that the signing of this modifies or is an extension of the existing contract?
Well, the language, I think the language of the agreement itself, because it applies to all work that's being performed by Everest on behalf of Height. So,
But the problem is that typically you don't modify a prior contract by signing a new one unless you allude to the prior contract. I mean, your client is basically amending all prior contracts with this one document without saying so, just saying, any work you're doing, and it's not even clear, any work you're doing, whether you contracted before or going forward, it's not specific, or is it?
It is. It applies to all work that they're performing, and there was still work being performed by Everest. Everest argues, they make an argument that they're almost arguing that because they were paid that this doesn't apply, or that contract was completely fulfilled, but it wasn't. The accident didn't happen until 9 months after the January agreement. It happened in October, 9 months after the agreement was signed in January, and it was ongoing. It's not, it's not past consideration. It is an ongoing business relationship, and it was something that they did every year.
In ongoing business relationships, you don't usually get to change the terms of the contract as you go along.
It's not changing the terms. It's just every year. They both testified every year they would enter into these indemnification agreements to cover all the work. So it was understood by the
This
parties.
language was the same every year.
Yes.
Okay.
Yes.
All right.
Thank you.
If I may,
Well, you have 1 minute.
I'm going to speak quickly.
You have 2 minutes.
I'm going to speak quickly.
You have 2 minutes.
If that was done every year, there'd be no need for the extra document. It wasn't done. There was no indemnity agreement that required my client Everest to indemnify Height. They may, for whatever reason, they didn't do it the year before, because otherwise I would have seen it in the record, I would have seen it in the motion, I would have seen it as an exhibit, I would have seen it in an affirmation. I saw nothing. So it was not done every year. And I listened.
Could a course of conduct, though, take a contract out of the ambit of 5-1105?
No, because it actually says expressly that you need to refer to prior consideration to be consideration. And the general rule under Castile against Caro, 134 AD 2nd 388, First Department 1988, says the general rule in this jurisdiction is that past consideration is not consideration. So, and going back to, I listened very carefully throughout the afternoon, and Your Honor, Judge Manzanet said, operating generally is not specific. So the fact that he says, well, generally we do it, he didn't do it this time. And you know what? That's their problem, not my problem. And you know what? At this stage, there's no consideration, there's no exception to the general rule. Therefore, if the court doesn't have any further questions, I'm done.
Thank you.
Thank you very much.
Lead versus luck. And you didn't have much luck being at the end of the calendar today, did you? Sorry. But at least this is it, right? Hi.
Oh.
Here. All right, let me get the clock ready. Okay.
I'm Stu Blander. I represent the appellant. Section 103 of 103A of the BCL says this chapter, that is the BCL, applies to every domestic corporation. The issue in this case is whether that statutory mandate can be squared with the lower court's determination that, as a matter of law, the plaintiff in this case, suing derivatively, has standing under 720 of the BCL based upon two pieces of paper, which are pages 240 and 241 of the record, and are the so-called 404 authorizations. As Your Honors will see, those authorizations are signed by someone named Joanne Welker, signed by C.K. Luck. However, as revealed by pages 885 and 890 of the record, C.K. Luck was not the incorporator. The statute is quite clear. The statute says that in order to appoint the initial slate of directors, that must be done by the incorporator.
You know that C.K. Luck was the funder of the capital funder of the
He was. He
right?
was.
So, I mean, I think that has some bearing on this, doesn't it?
It has some bearing if this.
I mean, his interests certainly were not in any formal way properly divested, were they?
It has some bearing if Your Honors decide, number one, that there's some kind of family business, small business exception to the requirements of the BCL, and it has some bearing if Your Honors conclude that he was the 100% shareholder, and neither things are true. taking the last thing first.
Even if he wasn't 100% shareholder, his interest cannot be divested willy-nilly. And it seems like they were.
We're not talking about, well, that's the issue in the litigation. The issue in the litigation is whether the corporation has been injured by the acts of Nancy Luck.
Right.
And that's the 720
The
Act.
selling of property, the tearing
that
down
stuff.
of buildings,
All that
creating
stuff.
a new building, and disinheriting everyone else in the family, basically.
All that stuff. Let's assume, well, she did all that, just to be clear. She did all that because from the period of 1980 to 2004, she was the only person running the show. That's undisputed. That for a period of 23...
So does that mean that because she ran the show, as you say, it allowed her some right to divest all her other family members of their asset and their interest in those assets? I understand what you're saying, okay? I totally get it. She does all the work, and now the rest of the family wants to benefit from it. But at the end of the day, it wasn't all hers.
Okay.
So
But at the end
where
of
does
the,
that leave us?
at the end of the day, Your Honor, in order for them to bring this claim, if I could go back to the law, in order for them to bring this claim, Dennis has to have been either an officer or director of these companies. And what they found that standing on is these two pieces of paper. And either these two pieces of paper comply with the statute, which everybody agrees they don't, there's no issue, or whether there is an exception because this is a family business. And what the judge said below is that even though it didn't comply with the statute, in fact, one of them, page 241, is not even signed. It's a piece of paper which, if we tried the case, would never come in. So what the judge said is, none of this matters because it's a family business. I have two responses to that. Number one, there's no family exception. When the legislature or the Court of Appeals wants to make a small business exception, they do it, the most famous example being, oppression under 1104. There is no exception. And even if you say for these purposes that the father could sign this, he was only 20%. So you have to create another exception. What's the other exception?
Oh, I don't know.
What's the other exception?
Because his wife died before him, so does he inherit her 20%? So
You don't
does
have
he
to-
now have 40%?
You don't have to reach that issue.
We don't know.
No, we do know. You don't have to reach that issue because my friend Ms. Levine says through her client in 3 or 4 or 6 places
Right.
that the father was only 20%.
Right.
And 20% shareholders,
At the outset, that's how it was divvied up.
Yeah.
20 the father, 20 the mother, but then the mother dies, and there is a consequence of losing your spouse, right?
but we're talking about 1973, Judge, when everybody was alive. And their
I
position...
thought you said this started in 1980.
No, the corporation...
No, I mean that she has been running the business since 1980.
Yes, from 1973 to 1980.
But her mother died in 1976, right? Did I get that date
I
right?
don't think so,
No?
Judge. I think
Okay.
much later.
I gotta look then. Go ahead.
But if I can complete
Yes,
my
please.
thought, in 1973, it is their position that the father, Chung Lee, was a 20% shareholder.
Okay.
Again, even if we cut him a break and say, forget about 404, that shareholders can sign and they can appoint directors, he was only 20%. And 20% shareholders can't do
So who elected Dennis Lee? How is it, right, that someone who is not even an actual member of the family,
No, he is. He's a son.
this is the son? Oh, okay.
Yeah. There are 5 daughters and...
I thought this was the husband.
No.
Okay.
He's the son.
All right. It is, yeah,
So
all
how
right.
is
So I
it?
gotta look at this.
I see
again.
if I can answer your question.
Yes,
How is it?
please.
Yeah. Our position is that he is an opposition from day one because we pled lack of authority in our answer, 100 years ago. which is on page 629 of the record, our position is he is not an officer and he is not a director, and therefore, not only did the judge err in granting summary judgment to Ms. Levine, the judge should have granted summary judgment to us. Because if there's no standing, and there is no standing, you can't bring the case. It's fundamental.
All right.
Thank you.
Good afternoon, Your Honors. Excuse my coughing earlier. But
I
it seems to be-
was actually referring to Chung Ka Luk.
Right.
That he's not a member of
C.K.
the
Luk.
underlying family.
Right, he's
and now he says he owns it all.
Yes.
And all of his children are the directors and the entire board, and the rest of the family has been wiped out.
Yes, that's correct, Your Honor. I don't need to repeat that part then. First of all, I just find it interesting that with all their theories about why this should be overturned, they do not challenge the breach of fiduciary duty, the waste, conversion, fraud, and there's another one in there, findings, because this can't be. This is uncontroverted. And just for just a little bit of background, these were family companies that were started by the parents, Madam Lee and Chung Lee, based in Hong Kong. Mr. Blander makes a suggestion that Nancy worked so hard and other family members benefit off her back. Yes, I'm sure Nancy worked very hard, but so did my client. The family had businesses in Hong Kong and Australia. My client worked, and this is in our on summary judgment, he worked very hard at long hours running the Hong Kong businesses and sometimes the Australia businesses. So this notion that somehow Nancy just is out there by herself and it's just unfair it's just bogus. And by the way, Madam Lee died in '93, Chung Lee died in 2006.
Okay, yeah, no, the 1996 is the resolution.
Right, the corporate resolution, yeah. So, in terms of the, and I don't think I made this very clear in my papers, the 404 statement, Nancy herself recognized the validity of that statement, and she did so when she was applying to China Trust for her loans. She had to submit, all these documents to him saying that the bylaws and the corporation are in full existence, and she did that. And she said that these bylaws are in effect. And the 404 statements also adopt those bylaws. So she can't have it both ways. I'd also mention that, he keeps the focus of Mr. Blander's argument as Chung Lee was only a 20% shareholder. There's another pending action, which is going to declare the
Over the mic a little.
the shareholding interests of the companies. But our position has always been that Chung Lee was 20%, Madam Lee was 20%, Dennis was 20%. That puts us at 60% from day one. And again, that the share ownership is not at issue in this case, but just to clear up the record on that. And I don't want to spend too much time on this, but if he is a director and an officer, it's clear under the law, because there was no further shareholder meetings, nobody else was elected, and he never resigned, et cetera, that he remained an officer and director till this day as a holdover officer and director under the law and under the BCL.
Is there anything in the record that controverts that when the father set up that Chung Lee established Lee Tai and 238-240 and directed the attorney to structure the ownership of the companies so that Nancy was the vice president? Am I correct?
Yes.
And Lee was the president? Am I correct?
Chung Lee was the president.
Yes. And the son?
Dennis.
Was he chairman or?
He was.
They all had officer positions in the company.
Right.
Correct?
My client.
And then there is no meeting that occurs after that would have changed that structure.
Exactly.
Legitimately speaking.
Exactly.
Okay? And the record shows that there were documents submitted for loan purposes that at best are created for the purpose of getting the loan.
Yes, that's very accurate, Your Honor. In terms of those loan documents, I want to go back to other documents as well, but in those loan documents, there was in 2001, 2, and 3, for the benefit of Nancy's solely owned companies. This was not done for the benefit of the family companies, as I'm calling them. She repeatedly represented to the bank that she was the sole shareholder, the sole director, and sole officer of Lehigh. In
And
2000,
in the meanwhile, there were tax returns being filed where she is just the vice president.
Right.
And other people are also signing those forms.
yes, my
for
client
these
Dennis Lee
companies.
says, yes. I would also just want to make the point that Nancy has waived her right to contest this, the 404 statement or any appointments of my client as an officer and director. She has repeatedly recognized his status as an officer and director of the companies in writing. She did it in a deposition under oath. She did it in 1996 in those proposed corporate resolutions that she signed. And yes, they weren't, their argument is that that's not valid to appoint him. We're not saying it is appointing him. We're saying that it's her recognition of his status. And then in 1996 also, Chung Lee had taken out $2 million in
Would
loans.
certainly constitute an admission against interest in light of the argument today.
Yeah, that's why all this is admissible as well. There's admissions against interest, party admissions, the whole gamut, and as well as it shows that she could not have had a good faith belief because she recognized in multiple documents before 2000 that Chung Lee had an ownership interest. Only Chung Lee knew who the officers and directors and the, who the shareholders were, the specific identity. So, and then I want to go back to 1996. 3 years before that, Chung Lee had taken out $2 million in loans from 238, 240, and Lee Tai. Lee Tai got audited 3 years later. Nancy went to Hong Kong to discuss the matter with Dennis and with Chung Lee. Why would she have done that if they weren't officers and directors of this company? She also wrote to them. She wrote to both of them discussing our worldwide operations that this would have a major impact on. And she also, sorry, I just lost my train of thought there. She also specifically referenced the properties in New York that this would have an impact on, calling them our properties. And then she separately wrote to Dennis that same year, asking for his consent to her proposed settlement with the IRS. I mean, I can't think of anything more clear where she's recognized this. One more thing, I know I'm out, but in her 2004 affidavit, she recognized that the companies are family-owned. This is after the China Trust transactions, by the way, and the transfers of the property. She also recognized Dennis was an officer. She attached tax returns he signed while he was managing the companies in the 70s and referred to him as an officer of Lee Tai in 238, 240.
Thank you.
Just for the record, they brought up a lot of other arguments, but it's all in my papers.
I'll try to talk very fast.
Yeah, because you got 1 minute.
Yeah, on page 35 of my friend Ms. Levine's brief, she says that Dennis became an officer in 1973. The issue is, and everybody agrees there were no meetings afterwards, everybody to remove. So the issue was, in 1973, could he have lawfully become a director based upon the evidence that they put before the court? And as Your Honor pointed out in one of the prior cases, in order for them to get summary judgment, it's not enough to present evidence. They have to affirmatively foreclose any genuine triable issue of fact. And they haven't done it here because the documents they rely on are legally insufficient. With respect to the tax returns, yeah, he signed tax returns as a director. My client signed a dozen tax returns that said that she was the 100% shareholder of the companies.
And that's the issue.
That's
the issue before the court, whether that was legitimate.
It's not really the issue because that's not
Ultimately, that is the issue in this case. That is
if they
what,
have,
that's the issue.
if they have standing to raise the issue.
Yep. Thank you.
Thank you. You too. Okay, take care. Nice to see you.